Who are you?
Well, in the second writ petition, which is WP 20940, in paragraph 21 to 28, certain aspersions has been made against my client, Mr. Montu Das.
Okay.
Well, because there has been a challenge to his caste certificate. He is a teacher. He's an associate professor in the Rani Birla College.
Ask the petitioner to impede you as a party and serve a copy of the writ petition. Let us hear him. What is the case of the petition?
Well, I will be filing an application.
You will file whatever you have to file. You will file. I will grant him liberty to impede you as a party and serve a copy of the writ petition. We are not discussing the
Very
writ
well.
petition right now.
I am applying for 4 and
4 and 5 in which one? 4 and 5.
4, 5.
So if it is item number 1, 4 and 5, then it will be different in the item number, the other one.
Sir, I mean,
5, Vice Chancellor. Sorry.
the matter I am applying for 5
and 6.
5 and 6. Label is
I started also. Now,
The Advocate General will argue, Mr. Bhattacharya.
I'm sorry.
The Advocate General will argue, Mr. Datta will argue today.
Mr. Datta is appearing for the state. In both these writ petitions, apparently, the governing body's actions are in question. Now,
Governing body is a part of the state.
no.
Governing body has been, we have been nominated by the state.
That nomination,
Yes, Mr. Sandal.
And that nomination is also under challenge in the first writ petition.
I am for the principal of the college. I joined on 20th September 2022 as the principal of the college.
Which paragraph you have stated?
That's your lordships. I give you lordships. না হ্যাঁ 218 না first petition টা
29 September.
paragraph 5 onwards paragraph 7 I joined the post office, and when I joined your lordship there was no governing body in the college, and college was being governed by the administrator appointed by the state. Now, I take your lordship, as I will be concise as far as possible because this is continuing for quite some time at the motion stage itself. Now, page 32. That's one of the impugned order. Now, the lordships will find this is of dated 9th June 2025. Subject: placement of president and state government nominees in the governing body of Rani Birla College. I am directed to say, as per provisions of the West Bengal Universities and Colleges Administration and Regulation Act 2017, the following persons are hereby nominated as president and the state government nominees in the governing body of the Rani Birla College, Kolkata, in cancellation of department's last order number dated, but I am not reading out order number, dated 16th March 2024. Your lordships may take note of this. The 16th March 2024 was the order of appointment of administrator.
Where is that?
The page 32, last paragraph of the first paragraph.
This
last
order you
line.
have not annexed.
This is not annexed. Subsequent writ petition we have annexed. This one, the administrator appointment. Oh, writ petition. Oh. আমি বলছি এই ক্যান্সেলেশন অফ দিস অর্ডার এই প্রথম রিট পিটিশনে নেই। যাই হোক, আপনি ছেড়ে দিন, বসুন। So I will take your losses there. So in cancellation of the order of administrator, these three persons were nominated as proposed member. Your losses will find first name, president, proposed as. Second name, Manos Kobi, state government nominee. Third member, state government nominee. You are required to take steps in this regard and furnish a report in this department at an early date.
Yes.
Then your losses will find the next page. As soon as the principal received it, he has taken steps for the election of the teaching and non-teaching category. Your losses will find at that page 33, 11th June, within 2 days. This is the schedule of election of the teaching and non-teaching staff. I will take your losses to the provisions law as to the composition of the governing body. Then your losses will find nomination, notice for nomination, page 34, under the regulations of the act, under the act to be constituted. Now your losses will find page 35. Nomination was finalized. These are the persons who filed their nomination, found valid. Page 35, that's of 17th June 2025. Now your lordship, after this your lordships, I just take your lordships to paragraphs 11, 12 and 13 of the petition, so that your lordships can get the sequence of the facts. Up to nomination, validity of
25, the state nominates some of the persons as president and state government nominee. How the 33 is related to annexure P1?
Related, your lordships, governing body consists of 10 to 11 members. These are the nomination category. Just nomination of 3 members by the state doesn't amount to reconstitution of the governing body. So other category of persons have to be inducted, and the law says how they are to be inducted. So next step have to be followed for reconstitution of the governing body. This is not monarchical system, this is democratic setup. Now your losses will find that's why 11th June notice was given.
Okay.
Then your losses will find page 34. The undersigned is hereby inviting nominations as per the West Bengal University College Administration Regulation Act 2017 from the teaching and non-teaching staff of the college for the governing body to be constituted in the college. So this was to be done. So that's why, my lord, the first notice was given. Now it is your lordships. Nominations to be submitted in a sealed envelope in persons. That page 34. And then last line at page 34, election will be held in the office of the principal. Now page 35, your lordships will find within the due dates, nominations were filed by the teaching and non-teaching representatives, members. And these are the, my lord, for the purpose of election, these nominations were found valid. My lord, there will be 3 teachers representative and 1 non-teaching representative on the reconstituted governing body.
One from non-teaching and 3 from
Teaching. Now, according to page 33, my lord, date of election is 19th June. If your losses take 33 and 35 side by side, your losses will find 35 is the 17th June notice. The nominations were declared valid. Page 33 lordships will find scrutiny of nomination on 17th June. That was done. Then last date of withdrawal of nomination 18th June, and then date of election 19th. Now, what happened after that? So that's your lordships will be finding from paragraph 10 onwards. Paragraph 10, page 8. I'm just placing your lordship 3 paragraphs of the petition. On 12th June 2025, your petitioner made the respondent number 7 to 9. Well, those are the nominated 3 persons.
Which page, sir?
Page 8, paragraph 10.
Yes.
On 12th June, your petitioner made the respondent number 7 to 9 the nominated president of the non-constituted governing body and make her acquainted with the situations of the college and about the said election of the college. This is the pertinent space to ventilate the truth that maybe the said notice as Pannexter P2 did not satisfy the nominated members of the GB. In view thereof, 13th June 2025, when the good number of teachers has gone to Asutosh College to invite one of the nominated members of the proposed GB of the college, Dr. Manoj Kobi, for the then ensuing annual day and farewell program celebration, which was held on 14th June in the college, the petitioner was directed not to hold any election, but go for selection. Well, this is the starting point of contention. The nominated members by the state wanted selection, no election. But law says there must be election in the category of teaching and not teaching. Then your losses, paragraph 11. Page 9. Accordingly, on the next day, that is on 14 June 2025, the principal has called all the teaching and non-teaching members of the college and conveyed the message as directed by the said nominated members of the non-constituted governing body. But all the members refused to go for selection. They refused, there should be election. Why selection? They unanimously decided to go for election amongst them to be represented by their fraternity in the governing body. Only 2 members, namely Montu Das of Department of Hindi and Konok Kumar Jana of Department of Philosophy, were surreptitiously abstaining from passing any comment over the issue, though they were present on the day of 13 June 2025 before the said nominated member of the non-constituted governing body at the Asutosh College. Well, this is Rani Birla College because one of the members of the nominated, he was the professor of the Asutosh College. That's why the principal met him. Then on 17th June, the petitioner principal notified the final list of candidates on the college notice board, whose nominations are found valid. Then 18th June, the respondent number 7, the nominated president of the non-constituted governing body, along with other one of the nominated member of the non-constituted governing body, Mr. Manoj Kobi, the respondent number 8, headed a team of other non-related persons with the said college, rushed towards the said college at about 5 p.m. in initiation of the respondent number 8. And as a result of the said visit of the Professor Dr. Manoj Kobi and his authoritative behavior and grave continuous threat and sublime intimidation, tells upon the health of conditions of your petitioner to be so deteriorated that she has to take shelter in a private hospital where she undergoes various treatments and tests, and she was discharged from the hospitals on 24th June 2025. But I tell you, lordship, this is the aftermath of that incident. But petitioner is also, my lord, a patient. The principal is a patient of thalassemia. That's, my lord, that's on record, admittedly, my lord. Anyhow, my lord, that's not the point over here. Now, after this, your lordships will find page 41. Page 41, your lordships kindly consider. Yes. This is of dated 2nd February 2022, when the college was under the administrator. There was no step taken, all your losses, for the reconstitution of the governing body. This 2022 notification was sent to the WhatsApp of the petitioner, since he is the principal, by the candidate as nominated by this notification. May I place it to your losses kindly? In pursuance of Rule 5V, Roman 5, of the West Bengal University and College Administration and Regulation Act 2017, the following person is nominated by the West Bengal State Council of Higher Education to act as the member of the governing body of the college, noted against his or her name until further order. Kolkata, Averi Guo, Rani Birla College, University, CU. The principal of the aforementioned college are requested to inform nominee of the governing body meetings held from time to time. Well, there was no governing body at that point of time. Now, these nominated persons, 3 nominated persons as page 32, they are of this year. So, this nomination of 3 years before, that nominated persons through WhatsApp sent to the principal that I am the one of the nominee. Obviously, the council must have a nominee. I will take place your lab. But this is the way this was placed. Now, your losses kindly see 42. Next page, continuation. This was addressed to, kindly see serial number 4 and 5, Register of Calcutta University and Register of the West Bengal State University. University. No, University of Kollani, sorry, Mal. Now, I tell your lordships, kindly see the non-application of mine. The Rani Birla College is a university of under the Calcutta. And this was registered informed to the Kollani University and West Bengal State University. A 2022 notification is now being thrusting upon the present principal that he should be. Why this sort of action? Why this sort of hurry without constituting the governing body? That's in this respect, one paragraph is relevant, your lordships. Of my
one thing that this 9/6/2025, this nomination made to 3 persons, is it correct? Or the governing body, once it is elected, this order will automatically go?
No, Malad, that's the point. I tell you, lordships. Normally, this is done like this, Malad. I will place that. First, election category as held. Then your lordships, teaching and non-teaching. This is the election. Then there are nominated members. Principal will be the ex officio secretary by operation of law. Then there will be 4. Then principal will say government and other authorities, please send your nominees. Then they will send. Malad, this has been done. Malad, put the cart before the horse. And what has been done, Malad, kindly see that malafide intention that I will place before your lordships. Malad, your lordships will find paragraph 14 at page 10. 14. That on the same day, one Mrs. Averi Guo, the respondent number 7, that's your lordship, page 41, send a WhatsApp message from her mobile with an attachment in PDF format, which claimed herself to be the nominee of the West Bengal State Council of Higher Education. The respondent number 6 herein, which is appeared to be fake or may be fake, and forged as the date of issue depicted there in 2nd February 2022. And the said notification is forwarded to the universities, which are or were not the relevant university of the petitioner. The petitioner submits that any of notice dated such far past cannot be applicable in this scenario of the events and thus be treated as vacant till date. The said alleged notification to be non-est, and it is also pertinent till date and filing of this have no formal or official mail of the letter is received by the petitioner from the respondent number 6. Respondent number 6, my lord, the council, who is to nominate. To consider the said Mrs. Averi Guo to be regarded as nominee of the college from the respondent number 6.
Yes.
Then your losses will find paragraph page 43. This is of 1st July 2025. Let me read out your losses. In my capacity as the president of the governing body of the Rani Birla College, I had advised the principal on 18 June 2025 to convene a meeting on 23rd June 2025 as serious complaint has been received from the teachers of Rani Birla Girls College regarding the matter of election of teachers representative for the governing body of the college and other academic and administrative issues. However, due to her reluctance to do so, I am hereby convening an emergent meeting of the governing body on 2nd July 2025 at 5:30 p.m. at Nivedita Hall, Rajeshwar Dasgupta Road, to discuss the following agenda. Malad, conventionally and normally, meeting of the governing body is held at the college premises. Now this is being outside the premises. And first, your lordships, my lord president, I will address that, your lordships, as proposed or president. My lord, before reconstitution of the governing body meeting is called upon. This is our basic point. First, reconstitution of the governing body to be completed. Before that, you have cancelled the appointment of the administrator, created a vacuum in the college, and nominated 3 persons. And through the 3 persons, you are asking for meeting of the governing body of the college without the other members. And kindly see the following members: Shravanti Bhattacharya, principal and secretary to the governing body; Manos Kobi Malab, the other nominated member; Sarthak Banerjee, the other nominated member; and the Averi Guho, the nominated council member. Malab, probably he is the Malab all the time to come to be a member of the governing body. As he 2022 he was informed wrongly to some other university, and then say in the 25 to be reconstituted governing body he will be the member. She will be the member. Now I replied to this notice as a principal of the college, page 44. Kindly see, I received this notice on 2nd July, 1st July. 2nd July, I replied to this, very subject, page 44, to the nominated president. Request to refrain from convening meeting of the governing body due to non-constitution of full body. At the outset, I would like to acknowledge your deep awareness towards the education at large, and particularly for Rani Birla College, by which I am grateful to be moved. However, I respectfully bring to your as well as other members, as depicted in your letter, attention towards certain statutory provisions that need to be duly considered before any meeting of the governing body is convened. As you are aware, the governing body of Rani Birla College is presently not fully constituted to function. As per the provisions laid down in the Higher Education Act 2017 and the rules framed thereunder, this is wrong. There has no rule has yet been framed. The governing body of an added college shall comprises of president, nominated by the state government; 2 state government nominees; 1 nominee of the West Bengal Council; 2 university nominees; 3 elected teachers representative yet to be elected; 1 elected non-teaching representative yet to be elected; and the principal of ex officio secretary. When the meeting was called for, your losses, university nominees were not also there. So, what actually the members, only the president nominated. I am questioning his nomination. That's another aspect of the matter, 2 state government nominees, 1 nominee of the council. That's also doubtful. And then principal. Then all together, your lordships will find 5 at least. 2, 3, 1, and 5. All are your lordships, either by ex officio or nominated members.
These 2 university nominees, this is there.
Not there. When this letter was issued, not there. Subsequently, they have informed before the other bench that they have been nominated. But when this meeting was called on and action was taken, they were not there.
They were there.
Get your chance, bro. University nominees have been appointed after this action has.
Exactly. Well, that's my instruction. Am I wrong?
So, 1 nominee of West Bengal State Council of Higher Education, that is Averi Guho.
Government. That's also I have told you, lordship, how can it be like this? 22 nomination. This is a new governing body. And president and 2 representatives. And the principal, the ex officio secretary. That's why she said that there is no committee reconstituted. Then, Malad, kindly, Malad, let us turn to the next page, page 45 of this reply to this president's.
Yes.
Next, page 45. As of now, the elected representatives of both the teaching and non-teaching staff are yet to be included. Considering this, I must respectfully point out that convening a meeting solely amongst the nominated members is not in accordance with the provisions laid down in the Calcutta University First Statute 1979, as amended up to date, which declare as state follows. The secretary shall call the meeting only if directed by the president in writing, or if at least 50% of the matters of the government of the requisitioning is. If such a meeting is not called within 10 days, the president may convene it. Additionally, the secretary is responsible for maintaining records, conducting a correspondence, and convening meetings, duties which are currently under my purview. In the present scenario, since the governing body is not yet formally constituted, the quorum is not legally made, any meeting held under such circumstances would be premature and statutorily invalid. But my stand was that let all the categories of members come up. Then, as a principal of the college, I will call upon a first meeting of the governing body. Before reconstitution of the governing body, there cannot be a meeting of the governing body. That was my whole contention, my lord. I will show to your lordships that this has a support of law. Now, my lord, kindly consider the page, next page. My lord, the rest I am not placing, my lord, because not required according to me. Page 47.
Yes.
Malad, this is a letter, your losses, left hand side top, addressed to the principal, date 3rd July. 1st July meeting, 2nd July my reply, 3rd July this so-called notice. This is the second, Malad. I prayed for certiorari. I am questioning this so-called notice. Malad, may I just place the first paragraph? As per the unanimous decision taken in the meeting of the governing body. But how there be a governing body on 2nd July 2025? You are hereby directed to show cause in writing along with supporting evidence by 5 p.m. on 11th July as to why disciplinary action should not be initiated against you on the following grounds. My lord, these are the grounds. All are according to me, my lord, fictitious, baseless. But let us proceed by your losses that these are valid grounds. Let us proceed against me. Now your losses, kindly see the next page. If no reply is received from you within the stipulated time frame, it will be presumed that you have nothing to state in your defense, and appropriate action shall be initiated against you as per existing rules and regulations. So, Malad, this so-called notice and the reconstitution of the nomination of the 3 members on the governing body and their actions, I have questioned in the writ petition. Malad, may I place the law? Then I will, Malad, develop my arguments. Actual copy. Yes. Look, I think the copy of the act in the file, if I'm not lost, is
Not here.
because this was. Just a minute. Let me take out my copy. আমার তো মিসপ্লেস হয়ে যাবে আচ্ছা আচ্ছা মালদা I am Well, I will be taking your losses to the relevant provisions.
The letter 44, this act has been wrongly quoted.
Page 40.
Page 44 in the letter of the principal, this act has been wrongly quoted as Higher Education Institution Management Governance Act. Yes.
Higher education institutions.
Yes.
That's your lordship wrong. Yeah, higher education, he has meant West Bengal University and colleges.
Higher Education Institute, Management and Governance Act, Municipal Act.
It's wrongly quoted. Title wrongly quoted.
The requirement as stated in the letter pertains to which act? This act.
This act. No, my lord, I take your losses to the relevant provisions of this act. My lord, kindly, my lord, definition clause, section 3, subsection Roman 12. না না আরো বেশি হ্যাঁ সেফলি গুলো তুই না আসা পর্যন্ত আমি শেষ করবো
Shanal will continue for
because the other I will place my lord consequential, so I will take little part.
half an hour.
Second up, I have other motions also.
What about
How long you will take?
I will take. My lord, I will be very concise.
But that concise is how much?
You are always concise, but এটাকে assess করে বল।
Okay, you continue.
My lord, there, let me, my lord, just, I will.
ঠিক আছে।
Well, my lord, governing body means, my lord, Roman 12. Governing body means the governing body of a college duly constituted. My lord, each word has a meaning here, according to me.
Only thing, Lord,
But if it is not, if Mr. Shanal does not conclude today, kindly keep it on next Friday for our submission.
On Friday means 12th.
This Friday or any other day, except tomorrow and day after tomorrow.
2 days you are not here.
I
Well,
may not be. I may not be.
My lord, I will be trying my best to confine, my lord, conclude it by this half.
না সেকেন্ড হাফে তো জশের অন্য মামলা আছে বলছে
অন্য মামলা।
Because at least I have to place it. I will not place, my lord, repeat nothing. But I have to place for the interim purpose.
Okay. Second up in দেখো মোশনে কি আছে দেখো 24 এর মোশনের আগে তুমি কন্টিনিউ করে দাও ঠিক আছে You make your submissions in the second half.
সেকেন্ড হাফ
I will try my best. Well, let's see the definition. Governing body means the governing body of a college duly constituted as per the prescribed procedure. Duly constituted as per the prescribed procedure and includes any managing committee or any other body for that purpose. But I am concerned duly constituted as per the prescribed procedure. Well, this can be two. Duly constituted means what the law conceives of. One, and the prescribed procedure. Well, this may be prescribed in the act itself or by rule. These are the two meanings, my lord, according to me. Then your losses kindly consider, my lord, section 4. Section 4. There shall be a governing body in every college to be constituted in the manner and procedure provided under the provisions of this act. So, my lord, if we go by the definition clause and subsection 4 of subsection 1 of section 4, therefore prescribed procedure means in the whatever in the act itself. Now, this is my submission. Now, your lordships will find now. Then your losses, the rest your losses according to me are not required. Then section 5. Notwithstanding anything contained in any other law for the time being in force or in any custom or usage to the contrary, the governing body or every government aided college shall consist of. Well, this is the requirement of law then. Shall consist of I will explain it, your lordships, to that. First, your lordships, the president shall be a person interested in education and shall be nominated by the state government from amongst the members of the governing body or from outside. This is first. Now, if your lordships kindly come to page 32, that's the impugned decision of the state. Now, president shall be a person interested in education. Now, my lord, I have two submissions. I make that submissions right now, then I will proceed further. My lord, your lordships will find page 32. There is no mentioning that the president belongs to the category of person interested in education. My lord, absence of recital that a person belongs to that particular category. My lord, takes us to the point that he or she doesn't belong to person interested in education. She has been nominated, but she doesn't belong to. Because the act says shall be a person. So, my lord, this must be an objective satisfaction of the state. It's not a subjective satisfaction. And your lordships also find proposed. He also nominated but proposed. I don't know, my lord, what sense does it carry? Is it a proposed member? Then he will be considered by the full governing body whether he can be accepted or not. That is another. But your lordships kindly see the next part of subsection 5 or 1. And shall be nominated by the state government from amongst the member of the governing body. Stop here for a moment, my lord. My submission is that after full constitution of the governing body, all elected, nominated from whatever, teachership, non-teaching, university, council, when all are nominated, it is for the state to decide amongst them anyone can be president or not. But why, my lord? Because it's an educational institution. Person must belong to the category of education. Any Tom, Dick, and Harry cannot be nominated.
Yes.
Now, you'll also, this is completely not done because, as I tell you, also only 4 members were there. Entire body has not come reconstituted. So, this was also not followed because this is the first step. And then your lordships from outside. If the state, obviously, state has the right to say that none of them I nominate. I can't, because according to me, these are not the proper persons. Then he has to choose, state has to choose from its own persons, from person interested in education. Then both are lacking, your lordships. The state way go from outside and persons do not belong to the state as a person interested in education. Because the first step was not followed from the members of the governing body, because, and this is conjunctive. And this is must, that the person must belong to person interested in education. That would first appear from the order itself, that he is being nominated as president in the person interested in education category. This is normally done. To choose your own person, you know that she doesn't belong to person interested in education. Now, I will not go further because that will create controversy. But this must appear, and this is objective satisfaction, not subjective, my lord.
Yes.
And therefore, my lord, this first nomination is contrary to law. Then your losses will find 2. The principal or the vice principal or the teacher in charge, as the case may be of the concerned college, who shall act as the ex officio secretary to the governing body. As I told you, Lossi Malad, as I informed you, Lossi, the principal is the ex officio government secretary. Then your losses 3 whole-time regular teachers, including librarians and graduate laboratory instructors, to be elected from amongst them. 4. 1 non-teaching employee to be elected from amongst them. 5. 2 persons to be nominated by the state government, and 1 person to be nominated by the West Bengal State Council of Higher Education. Malad, these 2 persons comes, Malad, page 32, the rest 2 persons. And Averi Guo, Malad, page 41, council, who was nominated 2022, even before the birth of the reconstituted governing body. All of them are that. Then your losses will find 1 representative from amongst the donor of the college. This category do not, Malad, exist. There is no donor of the college. 2 persons to be nominated by the affiliating university from amongst the eminent educationists. Malad, at least before the so-called notice dated 3rd July, this nomination was never came before to the college. So if any nomination has been done, that has been done after the so-called notice, which is now I'm challenging before the court. The university nomination. So these are the.
Where is the university nomination?
Malad, this is on the first paper, this subsequently, Malad. Okay. That your lordship in the second writ petition, I will show to your lordships. I will just show to your lordships. Kindly take note of, they're all after the incidents. Now, Malad, if I read conjointly, these are the 3 provisions in regard to reconstitution: 3 Roman 12, 4 subsection 1, and 5. My submission would be the procedure to be followed: first election, and then nomination by each of the authorities according to law, and then the first meeting of the governing body to be reconstituted governing body to be called upon by the principal. If the principal fails, president will call on. This is the law. So, Malad, before the birth of the reconstituted governing body, meeting has been called on, and I have been given so-called notice. Now, your losses, kindly see the next page. Oh, one thing, Malad, I missed it. Malad, next page of the act. 1 member is there, 1 student representative. That's another member, Malad. 1 student. There is no student election, I think, in any of the colleges in the state. So that's also missing. Now, the last proviso of subsection 4 provided further that 1/3 of the members shall form a quorum in every meeting of the governing body. Subsection 4, last proviso. Has you also got that one?
Subsection 4
of section 5. Provided further that 1/3 of the members shall form a quorum in every meeting of the governing body. Now, my lord, when the quorum can be formed, my lord? My humble respectful submission before lordships, when all the nominations or election is completed, then the total numbers comes to 10. 10, my lord, 1/3 will be the quorum. Before election, my lord, only 3 nominated members and 1 ex officio members will form the quorum of a body. My lord, this is a representative body. Everybody must have a say. When you say teacher is a bad person, other teachers must have a say about his activities. You just, my lord, came one fine morning by nominated persons and you were giving so-called notice. All of these, all of these, all of these. You must acquaint yourself.
Yes.
No meeting even you have held. So, my lord, this is the submission, my lord, that so-called notice is by a, my lord, authority who had not yet been constituted and no jurisdiction. Now, my lord, therefore, my lord, my first point in regard to that the governing body, there is no governing body in the college as conceived by the law. So there can a body which has not yet been formed cannot issue, my lord, a so-called notice. So, my lord, this is your lordships. 2012 না না 2012 আগে দেখালাম তো একটা না না হ্যাঁ শোকজটা এইটা দেখ হ্যাঁ এইটা 2012 ভলিউম 11 তো জজ সাহেবের তো নাই না কোনটাতে চলে গেল আমারটা মানে 2012 ভলিউম 11 SCC page 565 প্যারাগ্রাফ আরেকটা আছে ওই না আমি দিয়ে দিচ্ছি এটা বলা তো ও তুই তো নতুন না 2012 volume 11 SCC 565. My lord, I just, my lord, I'm giving it, lordships. My lord, this point, when I mentioned it as an urgent matter before Justice Bose retired, Mr. Sannal, I will dismiss your petition because so-called notice cannot be questioned. My lord, this is settled law, but this is equally settled. If it goes to the jurisdiction point, this can be entertained. Jurisdiction when root to the jurisdiction. If a body has not yet been formed, how can it have authority to question someone? Body has to be formed. If you do not have the jurisdiction, if you yet to be formed, then how can you issue the so-called notice? Nahi. I am handing up to your lordships. মুশকিল হয়তো কি করতে পারবো না ইকুয়ালি যতগুলো ফাইলে থাকবে কিন্তু তোমাকে বলতে পারছি তো যাইতে বার কর ট্যাবে বার কর मतलब paragraph 10 and 12. मतलब I just placed मतलब paragraph 10 and 12. मतलब 10. Ordinarily, a writ application doesn't lie against a charge sheet or show cause notice for the reason that it does not give rise to any cause of action. It does not amount to an adverse order which affects the right of any party unless the same has been issued by a person having no jurisdiction or competency to do so. Well, this is my point precisely. That one fine morning, 3 persons have been nominated and they are asking a meeting, calling on a meeting and issue a so-called notice. What the other way, a full body? What is your jurisdiction? It is yet to be formed in the prescribed manner under the Act. And that's, my lord, when the meeting was called on, I raised a question. You can't call a meeting. Then, your lordships, a writ lies when some party has infringed. In fact, charge sheet doesn't infringe. Well, this is the other point. Then, your lordship, paragraph 12. Thus, the law on the issue can be summarized to the effect that the charge sheet cannot generally be a subject matter of challenge. Your lordship can read it so cause also. Charge sheet or so cause cannot generally be a subject matter of challenge, as it does not adversely affect the rights of the delinquent, unless it is established that the same has been issued by an authority not competent to issue the disciplinary proceedings. Kindly have a look at the my lord. Consider the so cause notice. If you do not give the so cause notice reply, disciplinary actions to be initiated against you. So therefore, this is a prelude to the disciplinary action. So my lord, if person doesn't have any authority, how can he become issue this? Well, this was, I cited this judgment. The other judgment I tell you, lordships, 2012-4. এগুলো গুছিয়ে রাখবেন তো সিঙ্গেল জাজের জাস্টিস অনিরুদ্ধ দাস আরেকটা my lord, though this is my lord justice on single bench judgment, justice Aniruddha Basu, as his lordship then was up to the honorable Supreme Court, my lord, all that I'm trying to say, my lord, again I'm repeating at the cost of repetition that this is settled law. Charge sheet and so cause cannot be questioned. But if I can satisfy the conscience of the court on the point of law and factual aspect that the authority is not competent to do so, my lord, your lawsuit should interfere with it. Because I tell your lawsuits why. Now suppose at the end of it I succeed. Why should I, my lord, suffer this sort of harassment with persons who doesn't have the authority? A person questioning as a principal authority who doesn't have the authority to do so. Body has not yet been formed. Now, my lord, I show to your lordships paragraph 2021 and 32 to 34. লিখেছিস তুই তো 2012-4 Calcutta Law Times, page 291. Abdul Malik versus State of West Bengal.
21 and
30 to 34.
yes.
No, my lord, I think if necessary, I will go to my lord 2021. But I think your lordships, I place before your lordships the 30-31 first. Two other points are also are good.
Yes.
It was submitted on behalf of the petitioner that the condition of license was not violated by him as the intervener was never involved in their business of distributor undertaking in the terms of agreement at this initial. Well, this was also a question, a so cause notice, followed by the licensee issued by the control order. It was further urged on this behalf that in any event, the clause postulating automatic invalidation of the license in case of reconstitution of the firm was incorporated only after 2023 control order became operational. So far as the complaint of the intervener is concerned, changes in the composition of the firm, if any, took place before the 23 control order came into existence and no violation of conditions of license had taken place thereafter. From the copy of the license, I find that the same was issued in favor of the petitioner and MH as a joint proprietorship. I wanted to ascertain whether the license was issued to them as joint owners of firm or as partners, and I had directed the DDPS to clarify that the policy of the department on this point, an affidavit has been filed by such and such in favor of the partnership firm only disclosing the name of the partners. But this issue was clarified by the petitioner himself, and in the pleadings he has referred to himself all that. Then, my lord, kindly skip over 2, 3, 4 lines, and then on this point, I do not think the writ court would be the proper forum of adjudication. Various factual issues are required to be go that, all that. Now, page 32. I accept the argument of the petitioner that the intervener cannot implement a partnership agreement by making a complaint before the Food and Supplies authorities and such. The authorities would have to decide as to whether they are current or not. Then 33. In these circumstances, I quash the impugn notices dated 4th April 4th and 2020, copies of which has been district court had no jurisdiction to issue such notice. This is your loss of the point. No jurisdiction to issue such notice. If it goes to the root of the jurisdiction, my lord, therefore, the court can intervene in the matter. একটা জায়গায় যশে বলে দিয়েছিল এখানে যে লটা কি দেখবি তো একটা সেটা আমি দেখি। Your lordship, I'm not placing there because it will take time, your lordships. question of the two notices were questioned by the petitioner under the control order issued by the district controller. Court, he satisfied the court the district controller has no jurisdiction. It is subdivisional controller. And therefore, these two notices was questioned. Therefore, my lord, I sum up this submission of argument. First, my lord, 2 points, page 32. My lord, this nomination is not in accordance with law. And so cause notice by a body which doesn't exist, has not yet come into existence, is yet to be formed. So you cannot take this. Therefore, so cause notice, my lord, I'm paying for my lord, stay of the so cause notice. Now, my lord, kindly see the take the.
Mr. Sanal, one question: if the president is nominated in accordance with the law, in that event also, does the president has the jurisdiction?
No, my lord, unless the governing body is reconstituted. He is one of the nominated person, my lord. The other members to be instituted. Otherwise, it will be a monarch. The section 5 will be in futility. Then suppose your losses, what they are done, they are trying to get everything subsequently. Then it will take time, and it takes time. And you are taking action only with the 3 nominated members. Now, the other writ petition, my lord, may I conclude because the consequential, then your losses can hear them now. এটা কি রে এতগুলো কেন ও দুটো ভালো আচ্ছা আমি কোথাও নোট করেছিলাম না এটা আচ্ছা আচ্ছা এটা কোথায় দেখি প্রেসিডেন্ট এটা
এইটার উত্তরটা হোক না।
না না একবারই হয়ে যাক আমার 2 মিনিট লাগবে আমি কি করবো ওটার ভিত্তিতেই তো এটা জাস্ট মিনিট সাসপেনশন অথবা কোন মানে this next one I have been suspended.
Page number?
Page 127 of the next petition. Now I take your losses, just 2-3 documents of it. Kindly consider page 119. Page 119, 26th August 2025. Lord, kindly see, another emergent meeting was called for by the president. Kindly see page 119, only 4 members. If you also include president, 5 out of 10. All are nominated. Out of 11, only 5. Then your losses, kindly see page 120. Malad, I took the same point. Only the Malad title of the act is wrong. The governing body has to be constituted. Then your losses, Malad, page 122. Malad, I didn't participate in the meeting. Kindly have a look at this. Resolve that administrative and academic matters. The governing body of the college in its extraordinary general body meeting held on such and such, having taken into consideration the matters affecting the such and such, all such, it is expected for her that vice principal will discharge as duty. In the meantime, state has appointed the vice principal. There was no vice principal in the college because this is not pre-planned. Principal will be removed and vice principal will take the charge. She will be placed under suspension and vice principal will be placed in the governing body.
Yes.
Then your losses will find last paragraph. Now, because your losses, the first, second, third paragraph also taken. Insofar as the other aspect concerning the functioning of the college, it is noted that as per unanimous decision taken in the meeting of the governing body held on such and such, the principal of the college, Srimati Shravanti Bhattacharya, directed to reply along with the supporting evidence to a show cause notice as to why disciplinary action should not be initiated against her on the grounds indicated in the show cause notice. The governing body also notes that from the records available in the college, Dr. Bhattacharya had filed a writ petition in the Honorable High Court at Calcutta, registered such and such, in which Dr. Bhattacharya, apart from questioning the show cause notice, also prayed for a direction from the Honorable Court to set aside the notification of 9th June. That is the nomination of the President Adas, your lordships, whereby the President of the governing body has nominated by the state government. Be that as it may, it also appears from the record that the petition filed by Bhattacharya had on diverse dates, and from the now information available from the learned advocate representing the governing body as well as the Honorable President of the governing body, that the matter has been released by the Honorable Justice Basu. We have given to understand that the petition has since been assigned to the bench of the Honorable Justice Bivas Patnaik. There is apparently no order preventing or restraining the governing body in proceeding with further measures in relation to the show cause notice. Though the writ petition is pending, there is no effective order from the Honorable High Court which may be construed as impediment in the path of any other course of action. And then, my lord, giving the charges in the show cause suspension order and putting me under suspension. I will show, because my lord, we are mentioning assignment, your lordship fixing the date, they have suspended me. And now, your lordships, the last paragraph, I take your lordships, the one more paragraph. Just a minute, I missed it. Oh, no, my lord, then page 127. That's the resolution, and this is the suspension order. The same thing reiterated. I never, my lord, I've never seen in the suspension order, these are the grounds for suspension. Anyhow, my lord, dear lordships will find the page 130. The undersigned, empowered by the statute of the university, has decided to initiate disciplinary proceedings against you with effect from such and such. Has you got that one? Act in 1975. statute দিন দরকার নেই এদিকে এটাই দিচ্ছি কোথায় গেল 100 কত যেন 103 না ও যা কোথায় না না ঠিক আছে এখানে ক্লজটা কত ছিল যেন কই কেন কই কি মিলছে না কেন এটা মিলছে Well, kindly take note of. I just take a put mark. Well, this is the statute. This is 1979 statute. Can have a look at this. Non-application mine. This has to be done immediately. Disciplinary measures. Suspension always done in contemplation of proceedings. Disciplinary measures. Well, this is of statute of 1979. Now, your lordships. Oh, it is. Well, this is the state act. Now you'll also has to consider whether the act will prevail or the statute of the university will prevail. Kindly see, my lord. College definition means any college is affiliated to a university. Rani Birla College is affiliated to University of Calcutta. Then appointment teacher governing body. Now your losses will find section 11. Section 11. Suspension of teacher. The governing body of a college may place a teacher under suspension where an inquiry against him under subsection 2 is contemplated by the governing body or such an inquiry is pending. I have not, this has not been issued under the act. Second, there is no language that in contemplation of disciplinary proceedings.
Yes.
But the foremost point remains, my lord, whether some nominated persons of the governing body yet to be reconstituted have the jurisdiction or not. My lord, I am putting in this language. So that's the first point. My lord, therefore, if my first writ petition succeeds, so cause notice should go, consequentially suspension will go because the same persons have taken into same action. Now, my lord, I am showing this has been, my lord, once my lord, my junior said, my lord, that this has to be done by the supplementary affidavit. I said no, we have to take the next course of action by a fresh writ. So those. Now, my lord, my submission, if I succeed in the first writ petition on the point of jurisdiction, that's my first point of jurisdiction and the reconstitution memo, whether this is correct or not. Doctrine of consequential order will come into force. All subsequent acts to be declared illegal. Paragraph 27. Only this paragraph. Oh, 2000 volume 8 SCC 395. Only the paragraph 27. Paragraph 2. These, as you also got that paragraph 27. These follows from the general principle applicable to consequential orders. Once the basis of a proceeding is gone, maybe at any latter of time by order of a superior authority, any intermediate action taken in the meantime, like the recommendation of the state and by the UPSC, and the action taken thereon will fall to the ground. The principle of consequential orders, which is applicable to judicial and quasi-judicial proceedings, is equally applicable to administrative orders. In other words, where an order is passed by an authority and its validity is being reconsidered by a superior authority, like the governor in this case, and if before the superior has given its decision, some further action has been taken on the basis of the initial order of the primary authority, then such further action will fall to the ground and the moment the superior authority has set aside the primary. Malad, the first writ petition pending, kindly see, Malad. That's the ground, one of the vital ground. Pendency, no effective order, suspension. So, Malad, if I succeed in the first, then Malad, your losses. These are my humble for preliminary order. Only one thing, Malad, page 137 of the first writ petition, second writ petition. These are in the 2 volumes. These are only just factual losses.
Page 1.
Second volume. The second writ petition, second volume. There are 2 volumes because if it exceeds 100 some pages, second
Which page?
137. Second volume.
137.
Malad, dated 27 November 2020. Malad, I am showing how the governing body is reconstituted.
Yes.
Well, kindly have a look at this. This is addressed to the principal. I am subject government nominees to constitute the governing body of Rani Birla College. I am direct to inform the governor has been pleased to nominate the following persons in the governing body of Rani Birla College such and such. Professor Soma Bandyopadhyay. Well, a professor must be a person interested in education. I am not saying not any other persons. Then if he is from outside or from the arena of outside the arena of education, then one must say that these persons belonging to the person interested in education. Suppose if I elect some counselor, he becomes the person interested in education. So that's the application of mine. Well, kindly see then vice chancellor. None else than the vice chancellor was nominated as the president of the college. Vice Chancellor of the University of Teachers Training, Education, Planning and Administration. Then your losses will find after this 27 November. Kindly see what the then principal of the college did. 16th October. He requested my lord the governor for placement of the government nominee. See how the reconstitution and that. Then your losses will find page 139. He requested the vice chancellor to place the university nominee. Then you'll see page 40. He requested the governing body that inform the governing body government nominee that as soon as the meeting will be called on, you will be informed. Same was done the other members. And then your losses kindly see page 142.
In this case, the governing body was in existence.
No. Kindly see your losses. Page 137. First president, other two nominee was nominated. Date 27 November 2020. Get your losses. Then all the authorities asking for to give their nominee. I get your losses one. But kindly see page 138. It is addressed to the government. Request for name of government nominee of the governing body of the college. So I'm asking the nominee, other nominee. Kindly see your losses. Page 142. University. Page 142. Kindly see the date. Now election is being done. No meeting of the governing body in the meantime. How can it be? And the administrator was there. Full but this period the administrator was running the administration of the college. Kindly see this is the first meeting. So what is the procedure losses? Even the government nominates its representative, then the principal will ask for the other nominees and hold the election. Then all the members are elected, nominated, call for the first meeting. Then the governing body gets jurisdiction. Before formation, you cannot. This is my humble submission for the interim purpose. Part of the proceedings now.
We'll continue at 10.
One thing I'm trying to show your losses. Page just for factual background how this is being done. Just since your losses they have to what to bolo? Page ta bolun. এটা দিন না
আমাকে টোটালটাই ক্যান্সেল করে দিয়েছে যে এটা পাঠাচ্ছে আমাকে যে নোটিশ যেটা পাঠাচ্ছে অ্যাডমিনিস্ট্রেটর টোটালটা ক্যান্সেল করে দিয়েছে
বলুন এই পেজটা বলুন
Okay, at 2 p.m.
all it is না দরকার
সেভাবেই রাখবেন।
Item 218 and 219.
The Datta will argue later.
Yes. Now,
Your respond number 7 to 10.
One petition is 7 to 10.
and next one is 8 to 11. And the bank party name. May it please your lordship,
Okay. Yes.
for the present, please do not open the papers. With my limited knowledge, here, the name of the president nominated by the government has created all problems. A submission was made. I addressed that issue first. Page 32 has been questioned. Now, if your lordship compares page 32 with page 147 of the second writ petition, sorry, just give me 2 minutes. 137 with 32.
Second writ petition.
Yes, yes. Please. We will correct it. Now, it has been submitted by my esteemed senior that there is an absence of recital in page 32. And they rely on page 137 saying that in 2020 this was what happened. This is what happened. Please compare both of this. I am directed to say that as per provisions of the Act, the following persons are hereby nominated as President and State Government nominees in the governing body of such and such in cancellation of this department's last order dated 16th March 24. This is page 32. Here, as per the Act, the following persons in the pleased to nominate the following persons in the governing body of Rani Birla College. President and government nominee. Here also President has been nominated. State government nominee has been nominated. There are 2 state government nominees who have been nominated. And additionally, in 2020, the nominee of the West Bengal State Higher Council of Education was also nominated by the self-same order. It has been also submitted that this lady, who happens to be the vice chancellor of a particular university, her nomination as a person interested in education, it is presupposed by the petitioner that her nomination is proper because she happens to be the vice chancellor of a university. As against the fact that the president who has been nominated, she happens to be the councillor of the area in question. And therefore, her nomination as the president without a recital is improper. First submission to your lordship is the writ petitioner is allergic to the name, not the nomination, not the absence of recital, because in both these documents your lordship will not find any recital. Apart from
the designation is there.
It's a designation.
Designation.
Here also, The address is given and the president has been nominated.
So designation has not been given.
Designation, my lord.
At least you can presume that this person is attached to some institution. He is.
My lord, there is no such requirement legally. There is no such requirement legally.
So anybody
Legally,
can-
the requirement is the person who is nominated. My lord, please see the Act. 17 Act. Please see Section 5. Notwithstanding anything contained, it begins with a non-obstante clause. In any other law for the time being in force, or in any custom usage to the contrary, the governing body of every government college shall consist the following members. So, the governing body shall consist the following members include 1. The president, 2. The principal, 3. Whole-time regular teachers, including librarians and graduate laboratory instructors, 4. 1 non-teaching, 5. 2 persons nominated by the West Bengal State Council of Higher Education, under the West Bengal State Council of Higher Education Act. Then, my lord, representative from amongst the donors. Then 2 persons from the affiliating university. This much.
And one student.
Then
Student
one
representative.
student representative who shall be the general secretary.
Yes.
So, the total numbers of members. Now, in order to describe the president, what is recorded is the president shall be a person interested in education and shall be nominated by the state government from, we are not concerned with the first part, we are concerned from outside. From outside. Now, this is in the realm of an objective consideration by the state government, and it is their subjective satisfaction that this person, according to the domain by which the state government chose this lady to be appointed as the president, the state government's perception, which cannot, is in the realm of a consideration, which perhaps, in the absence of any material to the contrary, cannot be suggestive of that this nomination is bad per se, because, it is in the absence of, in the absence of any challenge thrown to the constitutionality of the particular provision, whereby the president is being appointed. It does not behove on any person not to accept the nomination. And, in the, though, this college, this act today is running the show, it is, governing the field.
President maybe will not be elected in case the outside elected only provided there is no risk.
So, the corresponding provision in the Calcutta University first statutes, which was in operation previously, in statute 93(2). 93(2). Please see 93. First page 93. A president to be elected in the manner prescribed in paragraph 2 or statute 93. That is statute 93 1A. Statute 93 1A. So there, my lord, the nomination aspect was not there. What was there? A president to be elected. Then, my lord, please turn to 93(2).
Here also election of the president.
Election of the president. My humble submission to your lordship is these entire provisions were done away with, were repealed with the promulgation of the 2017 Act. My lord, where do we get it, my lord? My lord, please come to overriding effect, section 21.
Yes.
I don't read it for your lordship, my lord. Your lordship kindly, my lord, sees. I'm pressing. Not it is non-obstante clause again. Anything contained in any other law or in any custom or usage for the time being in force, or in any statutes, ordinance, rules, regulations made by any authority under any law for the time being in force that is repugnant to the provisions of this Act. The provisions of this Act, to the extent of such repugnancy, shall have overriding effect against any such law, custom, usage, statutes, ordinance, rules, and regulations. So this Act is supreme today. This Act contemplates that a president shall be a person interested in education and shall be nominated by the state government from amongst the members of the governing body or from outside. The government chose to nominate some person from outside.
But then at the time when the nomination is being made, the government was also not having the persons of the governing body to consider them as well. Because all the factors are there. One is there has to be a governing body or from outside. So far as from outside is concerned, yes, the government can nominate a person from outside. But at the same time, was there any governing body where from the
The question of there being a governing body as in Statute 93 that was there prevalent, does not arise here. Here, a person can be yes.
My question is that in 5.1, it says that from amongst the governing body members
That is one situation.
or
from outside.
So both the situations should be before the government.
With respect, my answer to your lordship, most humbly is, this or here should be disjunctive. It is not, either of the two situations may happen. The government may choose to appoint someone from amongst the governing body or from outside. Or from outside. I can, after he finishes, because he's after all the learned advocate, he has the right of audience first.
Okay.
He can make his submissions, and thereafter, I can, because my action is principally under challenge, but the nomination by the state is under also challenge.
Your lordship may kindly take 2 or 3 dates. My lord, on 16th of March 2024, the administrator was appointed. Then, my lord, on 9th of June 2025,
February 2025.
9th of June 2025, Milord, 3 government nominees were provided.
Yes.
Milord, I have missed a date. Averike কবে দিল? 4th February 2025 তো? 4th February 2025. Milord, another nominee was provided. That is Averi Gupta, na? Guho. That is high secondary, তাই তো? But this is the high secondary council, Milord, who had provided the name of Averi Guho. হ্যাঁ, সেটা ঠিক আছে। But subsequent to the filing of the first writ petition, Milord, the University of Calcutta has also nominated their representative on 24th of June 2025. Now, for the time being, Milord, I am not, Milord, stressing on 24th June 2025. I am stressing on, Milord, whatever had happened prior to, Milord, issuance of the show cause notice on 3rd of July 2025. But your Lordship may now kindly have a look to, Milord, the West Bengal Universities and Colleges Administration and Regulation Act 2017.
Show cause was issued on 13th July.
Show cause was 3rd of July 2025. But that your Lordship would find, Milord, at page 47 of the first writ petition. Now kindly have a look to, Milord, the rules. Act. First is, Milord, the applicability of the Act, Milord. Your Lordship will find, Milord, section 2. This Act shall apply, kindly take II, to all colleges, including colleges run by the minorities, subject to specific provisions and exceptions made under this Act and the provision of the Constitution of India, and which are receiving financial assistance on a regular basis from the state government through the pay packet scheme. So it applies to colleges which receive financial aid from the government. This Act would apply. Now kindly take note the definition of governing body in section 2, subsection Roman 12.
Yes.
I'm sorry, section 3. I'm sorry, I stand corrected. I'm sorry. Section 3, 12.
Yes.
Governing body means the governing body of a college duly constituted as per the prescribed procedure and includes any managing committee or any other body for that purpose.
Yes.
Then please take, Milord, section 4. There shall be a governing body in every college to be constituted in the manner and procedure provided under the provisions of this Act. Notwithstanding anything contained in any other law for the time being in force or any custom or usage to the contrary, the constitution, powers and functions of the governing body of all colleges shall be uniform, irrespective of the nature of their promotion or sponsoring bodies. Provided that the government-aided colleges run by minorities, we can skip over that. Now please take 3. Notwithstanding anything contained in any other law for the time being in force. or in any custom or usage to the contrary, the state government shall have power to dissolve the governing body of a college other than the college run by the minorities if it is if in the opinion of the state government that governing body of the college is unable to perform its functions as per provision of this act or the statutes of the affiliating university or the continuance of the governing body or any of its members in such governing body is detrimental to the interest of the college, and in every such case the state government may appoint an administrator in place of the governing body who shall discharge all functions for such period as may be determined by the state government or until constitution of a new governing body, whichever is earlier. Therefore, my lord, in a case where the state government dissolves the governing body for reasons which are provided, my lord, in that case, the state government may appoint administrator in place of the governing body. My lord, this phrase is very important. Till such time, the governing body is reconstituted. আমাদের অ্যাডমিনিস্ট্রেটর অ্যাপয়েন্টমেন্টের ডকুমেন্টটা পিটিশন অ্যাডমিনিস্ট্রেটর অ্যাপয়েন্টমেন্টের ডকুমেন্টটা অ্যাডমিনিস্ট্রেটর অ্যাপয়েন্টমেন্টের কাগজটা কোনোদিন করতিস তো কোনোদিন
This has not been annexed to the writ petition.
No, it's not annexed to the writ petition. I'll come back to that.
My lord, it is annexed to the writ.
আছে কতগুলো পাতা
Second petition.
second
Second petition.
I'm
Not in the
there
first. Not in the first, my lord.
but I'm not there in the second one.
What is the page number?
Page number.
Should the second to the G?
Correct.
Copy আমার
Come,
কাছে
sir. Right.
অপূর্ণকে অ্যাপয়েন্ট করে
My lord, 163 to 167 of this.
এটা এলো অপূর্ণার জায়গা অপূর্ণকে অ্যাপয়েন্টমেন্টটা সেটা আছে
Of second writ petition আছে।
না প্রথমটা আছে অপূর্ণা
হ্যাঁ, সেটাও আছে। শম্পা দত্ত পাল ও অপর্ণা কেক। তিনটে
এটা কত জায়গা আছে দুই বলছি
163 to 167.
163 থেকে 167
আমি research with all that. Pages. এই যে অপর্ণা এই অপর্ণা আর এই
But 163 is the first one, তাই তো?
Yes.
But 163 of the second writ petition, placement of administrator of Rani Birla, so and so. In exercise of powers conferred by 4(3) of the Act, I am directed by order of the governor to say that the governor is pleased to dissolve the governing body and to appoint so and so as administrator of so and so college. I am further directed to say that so and so will act as administrator until constitution of the governing body.
Yes.
Or until further orders, whichever is earlier. Then, my lord, the next one is page 164. Now, my lord, the Dr. Shompa Datta Gupta is now replaced by Dr. Aparna Chakraborty. This is page 164. And then third একটা কোথায় পাবো? তারপরে
167.
167. And finally, beloved, on 16th of March 2024, Dr. K.K. Trivedi replaces Dr. Aparna Chakraborty.
Yes.
So until reconstitution, all these three appointments. Now please take beloved section 5. Or subsection 4 also, kindly have a look of subsection 4 of section 4. The affiliating universities shall in every such case take steps to constitute the new governing body of such college referred to in subsection 3 within such time as may be prescribed. Now the main section is section 5. Notwithstanding anything contained in any other law for the time being in force, or in any custom or usage to the contrary, the governing body of every government-aided college shall consist of the following members. First one is president, shall be a person interested in education and shall be nominated by the state government from amongst the members of the governing body or from outside. We have twice I skip over. Then II, the principal or vice principal or the teacher in charge, as the case may be, of the concerned college, who shall act as ex officio secretary of the governing body. Third is 3 whole-time regular teacher, including librarian, laboratory instructors, to be elected from amongst them. 4 is 1 non-teaching employee to be elected from amongst them. Then 5 is 2 persons to be nominated by the state government and 1 person to be nominated by the West Bengal State Council of Higher Secondary Education, constituted under so and so. Then 6 is 1 representative amongst the donor of the college. Then 7 is 2 persons to be nominated by the affiliating university, eminent educationist, etc. And 8 is 1 student representative who shall be the general secretary of the duly constituted students' body or union, as the case may be. Now, this is, Milord, the composition of the governing body of a college. Subsection 2 says all existing members of the governing body which are constituted immediately preceding the date of coming into effect of this act shall continue, etc. We skip over that. Kindly skip over subsection 3. Now please take subsection 4. Every meeting of the governing body shall be convened in the name of the president, provided that the president's absence in any meeting shall not invalidate, etc. Then the second proviso is provided that, but kindly take this. This is very important for us. Provided that 1/3 of the members shall form quorum in every meeting of the governing body. 5. Powers and functions of the governing body shall be such as may be provided in the statutes of the affiliating university. Now here, my lord, I have placed before my lord that the government initially, my lord, had appointed 3 persons, 3 nominees. Then came the nominee of the West Bengal Higher Secondary Council. So 3 plus 1, 4. Plus the 5th member was the principal, that is the petitioner before my lord. Therefore, 5 persons were there. My lord, the total composition as per, my lord, subsection 1 of section 5 is, my lord, for this college there would be 11 members. Why 11? Because there is no donor member in this college. And there is no general secretary of the student representative. Therefore, minus this 2, the maximum composition of this college could be 11 persons. Now the question is that 1/3 of 11 would be 4. We have 5 members in the governing body of the college, which includes the principal, that is the petitioner before my lord. Well, I have got twofold submission. First limb of submission is the statute is framed in such a manner that it does not say that what is the minimum number of members required to form a governing body. Well, these are the persons in total 13 mentioned, of which according to us 2 cannot remain present because we don't have those 2 categories. Therefore, 11 out of 13 is the maximum that can form the governing body of this college. Unlike various other statutes, this statute does not mention that out of 11 or 13 there must be at least, say, half or 3/4 to constitute a valid governing body. It does not say so. Therefore, a governing body can be of persons less than 11 also, 11 or 13 as the case may be.
Can be less than 11.
The only thing that, my lord, the statute provides is that to form a quorum in the governing body, it must be 1/3 of the members.
Tell me one thing, that K.K. Trivedi has been removed. The administrator has been removed.
Yes, yes. Administrator is no more there.
Okay.
After, my lord, the placement of yes. Page title of the first one or second?
Nominees have been made.
Yeah.
Nomination has been made of such persons.
Cancelling.
My lord, dear lordship, may kindly take, my lord, page number 32 of the first writ petition.
So this cancellation is of that order of K.K.
16th of March.
Yes.
So this cancellation of 16th of March is the reconstitution.
Yes.
So, well, the first submission is that, my lord, the statute does not provide what should be the minimum number of members to form a, to have a, say, so-called valid minimum number to form a constitute a governing body. And number 2 is 1/3. But in our case, there are 5 members,
Yes.
including the principal. My lord, 4 had, my lord, attended the meeting, which had taken all these decisions. That your lordship will be considering, my lord. The college will make submissions. I don't think, my lord, I have authority to make any submission on behalf of the college. But so far as the reconstitution is concerned, my lord, according to me, going by the provisions of the statute, my lord, there was a validly constituted reconstituted managing committee with 5 members. And this 5-member committee was legally capable to, my lord, take all decisions. Now, of course, my lord, 2 other members have been nominated by the university. Therefore, it is 7 as of now. But this is the first point which my learned friend has taken, my lord, in the first writ petition in para 21. But in the first writ petition, please take para 21. Well, before going to 21, please take 20. Where the petitioner also accept that there should be at least 11 members. In view of the fact that non-constitutional GP, there cannot be any quorum, as there is to be total at least 11 members. Now please take 21. Hence, according to the rules, in the absence of quorum of the members of the GB has not yet been formed, constituted. Moreover, according to the first statute of the Calcutta University for the first GB, the meeting is to be convened by the principal so and so. First point is there is no quorum, my lord. According to me, there is quorum. The second point is I do not know whether, my lord, in course of verbal submission this has been made or not. But as per pleading, according to them, the Calcutta University first statute is to apply. But I don't think, my lord, they'll go by that because Calcutta University বলেছে ও submission করেছে আচ্ছা if Mr. Sanyal has made this submission, kindly have a look to, my lord, section 21 of the act. Overriding effect. Notwithstanding anything contained in any other law or in any custom or usage for the time being in force, or in any statute, ordinance, rules, regulations made by the authority under any law for the time being in force that is repugnant to the provisions of this act, the provisions of this act, to the extent of such repugnancy, shall have overriding effect against any such law, custom, usage, statutes, ordinances, rules, and regulations.
Yes.
Therefore, my lord, Calcutta University first statute gets overridden by reason of, my lord, section 21 of this act.
Yes.
Now, my lord, assuming for argument's sake, Mr. Sanyal's submission is correct. Let us assume for argument's sake that legally it is a correct submission. Then, my lord, the corollary is that Mr. Sanyal submits that no disciplinary proceeding can be taken against any person at this stage. There, my lord, of course, my lord, I am not appearing for the college. There, my lord, the doctrine of necessity is to be applied. Where, my lord, it is found that there is a stalemate, I don't agree to that. But assuming for argument's sake, there is no governing body as has been contended. Then also, my lord, with these 4 or 5 members, by the application of doctrine of necessity, my lord, proceedings can be initiated. It cannot be said, this is alternative argument, I do not know whether I should make this argument or not, but since it is a legal submission, I think, my lord, your lordship will permit me to make this submission. And the third aspect of the matter is, again assuming Mr. Sanyal to be correct, my lord, a statute is not to be interpreted in a manner to reach to a redundancy. This is what your lordships have held, that the courts will not read a statute in such a manner that it ultimately results in a redundant situation in interpreting the statute. If the contention is that no, to be a valid managing committee, there has to be 11 out of 11. Otherwise, there is no valid managing committee. In my very respectful submission is neither supported by any provisions of the statute. Otherwise, it will amount to rewriting the statute, putting words into the statute. Because if the legislature felt that no, either 11 or 13 must be there to be a valid managing committee or a governing body, my lord, in that case, the legislature would have provided. And if it is considered to be a casus omissus, where the court will not put the or fill up the casus omissus, where the legislature was competent enough, wise enough, had its eyes wide open to provide that no, for a valid managing committee, all 11 or 13 persons must be there. One less or 2 less, not a valid managing committee or a governing body. When the legislature has not put a particular number,
Yes.
This casus omissions cannot be filled up by the court. And the legislature contemplating a potential dispute on this issue has provided that 1/3 of the members will be a valid quorum for a managing committee.
Yes.
These are my submissions. But on the show cause notice, reply, etc., I think the college is better. No, on the issue as to whether the person who has been nominated as the president is a person interested or not, but I don't think this is a proceeding where this can be gone into, unless your lordship wants me to respond to it, because these are issues where your lordships have held that there are no judicially manageable standards in judicial review to find out whether X is competent or Y is more competent or Z is less competent. That has to be left to the executive, whom to choose. I do not know whether this point has been urged or not. If it has been urged, I don't know about the second petition, but in the first writ petition, please have a look to the prayers. Please have a look to the prayers. I don't think there is any prayer, questioning the appointment or nomination of that person. But kindly look into the prayers, of the first writ petition in which I am appearing. I don't think there is any prayer for quashing of this notification of 9th of June 2025.
Yes, it is there.
Yes, there is a prayer, 4, Roman 4. Yes, very well. The prayer is there. I stand corrected. But there are decisions of the Supreme Court as well as of our High Court made on this aspect.
Will the state be filing any affidavit to the allegations which has been raised, or your submissions is restricted to the interim order which has been sought for by the petition?
Finally, we have to file our affidavits because there are certain allegations which need to be dealt with. But we're on the issue of the competence of the or reconstitution of the governing body. I think the state has a role, and the state needs to apprise your lordship on the legality of this the entire issue. Therefore, I restrict my submission to that. But so far as the show cause notice is concerned, I don't think I should open my mouth, subject to your lordship inviting me to open my mouth.
For that reason, respond number 7 to 10 will.
Yes, because the college has taken a decision. I am a person, or I am the state. I provide funds. I nominate persons in the governing body.
Okay.
And in a case of necessity, administrators are appointed, reconstitution are made.
Yes, that's all.
Mark করা আছে দেখ। Lord, submissions have been made in support of the fact that the reconstitution is going on under process. There cannot be any backup. On and from, the law as it stands in section 5 of section 4 we have to read this, strict interpretation has to be given to it.
Yes.
There is in section 5, subsection 4, the contemplated invalidation, where that the president's absence in any meeting shall not invalidate in the event if any of the nominees of the state government is present. So, in the event, the president is absent and, the nominees of the state government are present, the meeting will be proper. In other words, it does not invalidate the meeting. Apart from that, it specifically says in the first sentence, every meeting of the governing body shall be convened in the name of the president. And the second proviso says, provided further that 1/3 of the members shall form a quorum in every meeting of the governing body. Presupposes the members who are on the particular day will not be availability because the governing body will not. The president has been nominated, the state government nominees are there, the Higher Education Council has nominated. Calcutta University's nomination is for the first time disclosed in the second writ petition. It was not disclosed previously because if your lordship sees the communication apparently is addressed to the principal of the college, not to the president, not to anyone else apart from the principal of the college. She was in the know-how of such, special fact, if I may say so, with greatest of respect. Now, this principle from day one, the moment, page 32 of the first writ petition came to be issued,
Yes.
she started, playing foul. First is she chose, for whatever reasons, whatever was her mindset at that special point of time, she chose to completely defy all directions of the nominated president. All directions, because according to her, the president is no one. She is the supreme person inside the college, and she can behave in any manner ignoring the existence of the nominated president. Now, where do we get it? If my lord kindly takes the trouble to come to the first writ petition. Now, please see, page 32 is the first document. Then, my lord, attention of my lord was invited to page 33.
Yes.
My lord, there nowhere your lordship sees, my lord, that there is any cognizance or, my lord, ratification, or, my lord, it has been at least rooted through the president of the governing body. These are all unilateral actions. Notice of election, governing body election. Then, my lord, she goes to the extent of also declaring at page 35 the nominations which according to her stood valid. Huh? Yes. Now, attention of my lord was also invited to page 41 and 42 of the writ petition, the first writ petition, and it was suggested that it was complete non-application of mine. Now, immediately after issuance of this particular document, my lord, there was a corrigendum which was issued rectifying the situation. My lord, at least, my lord, I can expect as an officer of court that facts would be correctly presented to your lordship. Your lordship was looking at page 41. When attention of the previous bench was invited to page 41, we had informed the previous bench of this document dated 4th February 2025. We also, if I am not mistaken, handed over this document, and which must be in your lordship's file. Now, this is in partial modification.
Next to the writ petition.
No, annexed to the writ petition is the incorrect document.
No.
That was supplied to us.
You have placed it before the earlier bench.
Yes.
But that was not supplied at that point of time, Malad. This is my humble submission. Number one. And number two is this. This is no, that is not the. No, ওই খালি বলছি যে বলছেন যে এটা আমাদের আর দিইনি রিট পিটিশন অ্যাকচুয়ালি এটা সাপ্লাই করেনি
Milord, what I am humbly suggesting is, Milord, attention of your lordship was invited to page 41 and 42. And it was suggested that since the name of the university is recorded as Kolani, since it is a 2022 document, this is sheer non-application of mine. That is what the submission was, if I have correctly heard him. Milord, what additionally could have been pointed out, maybe, Milord, I accept the position, Milord, factually, that this document was not in their hands. But the fact that this document was disclosed to the court could have been informed to your lordship that there is a document of 4th February 2025 which clarifies the entire situation by saying that in partial modification of the office order dated 2/2/2022 and in pursuance of rule such and such, the following person is nominated. And Milord, it is the same nominee. Please see the next page. Kindly see the name of the university. All things are clarified. And it is also, Milord, a copy is served to the principal of Rani Birla College for necessary action. Serial number 8. Milord, I do not want to trouble your lordship by inviting your lordship to serial number 8, but only, Milord, I am tempted to show your lordship serial number 8 because, Milord, attention of my lord was invited to page 42 of the writ petition by inviting your lordship to serial number 4.
Yes.
And if serial number 4, Milord, then serial number 9 is also there in page 42. Milord, it is incomprehensible if the principal of the college has page 41 to page 42, then this document is also served on her. It is presupposed Whatever it is, I take it that she does not have it. But fact remains, this is the ratification, the rectification. Now, my lord, regarding the reconstitution part, my lord, has been extensively shown by the learned Advocate General, section 5. Here, the first stage is president, the second stage is principal, the third is, my lord, 2 persons under serial number 5 have been nominated. 2 persons and 1 person.
One is the president,
Yes. One is the president who has been nominated.
persons nominated, and
Then
one
2 persons to be nominated by the state government. Those 2 nominations are also there. And 1 person to be nominated by the West Bengal State Council of Higher Education, constituted under the Act of 2015. So, my lord, we are covering, by dint of these nominations, 5155. And by dint of the university, my lord, 57 is also over. 7 has come later. It has been disclosed later. We never had a toehold of 7. We never had a toehold of 7. 7 has been for the first time disclosed. Where is 7 disclosed? My lord, 7 is disclosed in the writ petition. No, not 1. Not 1. Second volume. 168. 168. I'm grateful to my learned friend, my lord. 168 is addressed to the principal. And copy forwarded to, my lord, to the concerned persons. In 2025 June, 24th June 2025, my lord, this is addressed to the principal of the college. And your lordship will see, my lord, copy forwarded to. Nowhere your lordship will find even, my lord, a reference to the president or the GB. Yes, principal could have submitted. She has disclosed it here for the first time. Not even in her first writ petition. Her first writ petition was carried to your lordship's court, my lord, on 9th of July 2025. On 9th of July 2025, it presupposes 24th June 2025 was with her. For whatever reason, she has chosen not to disclose. She has disclosed it in the second writ petition. My lord, the next submission to your lordship is, a lot of submissions have been made regarding the issue of jurisdiction. It has also been submitted that if the first 9 July document goes in the first writ petition, if the first writ petition, if page 47 goes, the show cause, if the show cause goes, page 47 goes.
Suppose is 3rd July.
Yes, 3rd July. 3rd July. 3rd July. If page 47, 48 goes, then the next consequential action will also not be there. My humble submission appearing for the governing body of the college is, section 5(4) second proviso clearly says 1/3 of the members shall constitute quorum. 1/3 of the members, if your lordship makes a sum total of the number of members, your lordship will be pleased to find from the act, total is 13.
11. In this case.
Donor is not there and guardian's nominee is not there. Students nominee. Students. So 11. Out of 11, 5 persons existed, 4 persons existed apart from the principal of the college. So 1/3 of 11 is definitely, my lord, more than 4. 1/3 of 11, it is definitely, my lord, out of 9 members, it is 3. Out of 10 members, my lord, it has to be something, my lord. So 4 members, whoever were present in any meeting, my lord, in my humble submission, contrary to the previous 93 statute, 93 statute and this, if your lordship reads together, your lordship will be pleased to find that there's a complete, my lord, divergence insofar as the constitution of the governing body is concerned. The 93 statute I am handing over to your lordship. Just
Once again, I was asking Mr. Dotto,
my lord.
the removal of the administrator Keka Trivedi, that order, though the order has been reflected in 9th June, but the order is not before annexed to this writ petition, I suppose. Whether you have a copy of that, whether you have a copy of that,
9 June ये order था.
where the reflection of that Keka Chaudhary has been cancelled.
So that is the order.
That
is the only order.
If you see, there are Aparna Chakraborty was there. Prior to that, there was other administrators, and by order, they have been removed one after the other. Now, Keka Trivedi has been removed as an administrator. What was the direction in that order?
Page 167 of the second writ petition.
That is their appointment. না না কেকা ত্রিবেদী রিমুভাল
এখানেই তো কেকা ত্রিবেদীর জায়গায় দেওয়া হলো
Yes, Keka Trivedi was appointed by this 16th March document.
Yes.
Now, if your lordship reads 16th March document together with page 32, in cancellation of this department's last order is page 32. What your lordship is desiring, my lord, that whether Keka Trivedi independently was informed about her removal.
I'm not in that.
I'm sorry.
In appointment, in the second paragraph, it says that she will discharge in addition to her normal duties until reconstitution of the governing body
Or until further order.
or until further order.
Whichever is earlier.
Interregnum,
Yes.
when there is a process going on of constitution, reconstitution of the general body, what was the function of the administrator?
Sorry. I'm sorry, sir. Sorry.
Was the administrator cessing of the administration of the Rani Birla College or not, till the governing body is appointed or nominated, whatever? Because my question is related to section 5. Section 5 says that there has to be a governing body out of which 1/3. Supposing if there is no such constitution of the governing body, how could you assess 1/3 of the quorum?
My humble submission is from the entirety of the total number supposed to be in the governing body. If 1/3 is present, that constitutes
Also
quorum.
that says that
Because people pour in. People pour in. First here, unlike the previous one, here persons are nominated to hold the chair of governing body member. Thereafter, my lord, whoever is to pour in the sense, my lord, kindly falls back to the act. My lord, the principal is ordinarily an ex officio member of the governing body. That is 5(2). She is the secretary of the governing body by dint of her post. Then, my lord, 5(3) contemplates an election. 3 whole-time regular teachers to be elected, 1 non-teaching staff to be elected. So 3 and 4 have to pour in. Then, my lord, 5 is complete here. My lord, donor has also got to pour in. In the absence of a donor, it cannot be said that the governing body is not constituted. Then, my lord, 2 persons from the affiliating university, they have also been nominated. So total we have, including the principal, 7 persons, excluding the principal, 6 persons. And, my lord, in the context of student union, there is no student union, my lord, in any college in West Bengal today. So therefore, if your lordship, my lord, kindly visualize this from the purview of a complete, my lord, strict interpretation provides, subject to correction by my lord, your lordship, what is passing through your lordship's mind. I am trying in my most humble way, my lord, to answer your lordship. Your lordship, if your lordship has to look into the 93 statute, please look into the 93 statute. The 79th statute, statute 93. Shall consist of the following members. And while shall, in this shall, my lord, a president is to be elected, it says. Principal, then 4 members from amongst whole-time teachers, etc. At a meeting to be convened by the principal. The principal shall not vote. 2 representatives of whole-time non-teaching. In case of tie, etc. 2 members nominated by the state government. 1 of them shall be an educationist. 2 members to be nominated by the syndicate. 1 of them to be, of whom at least 1 shall be a woman in case of a women's college. 1 representative from the students, not more than 2 to be nominated by the vice chancellor in consultation with the pro vice chancellor for academic from among the donors. Then, my lord, no teacher or other employee who is a donor shall be nominated as such member. Then, my lord, I kindly sees the councillor of the corporation within the jurisdiction is situated, provided he is neither a teacher nor an employee. So, my lord, there specifically the councillor of the corporation, the chairman of the municipality, the Shabadipati of the Panchayat Samiti, within the jurisdiction of the college, provided he is neither a teacher nor an employee nor a student of the college concerned. If under any circumstances the person concerned happens to be a teacher or an employee or a student of the college concerned, the respective organization shall send its nominee, who shall in no case be a teacher or an employee. So, in the previous statute, specifically councillor or a people's representative was provided. Here, that has been excluded completely. It is not exclusion by implication. It is an exclusion by statute. And, my lord, statute 93 thereafter says there has to be an election of the president. 93(2). No such provision exists here, like 93(2). What exists, my lord, after 5, after your lordship sees up to 8, 5, 8, straightway, my lord, takes the trouble to statute 5, I'm sorry, section 5. Statute 5, section 5, I'm sorry. Now, please come to after Roman 8, 518.
Yes.
We are not concerned with 5.2 for the present, but this is what it says. What my lord will not get in this section 5 is a provision similar to 93(2) of the first statutes.
Yes.
On the contrary, it says every meeting of the governing body shall be convened in the name of the president. Here also the same situation. Strictly in terms of 2017 Act, meetings have been convened. And it says, provided further, that 1/3 of the members shall form a quorum in every meeting of them. 1/3 of the members is, we can't wait for the donor to be nominated. We can't wait.
There is no donor of a college.
Then means the governing body will not be constituted. I put this question entirely to myself. If today Higher Education Council or the university takes 8 months to nominate, your lordship knows, today the universities are functioning with
One aspect is silent in the act is that if suppose there are 5 members which constitute the quorum of the general body, but the election of the members of 3 teachers and 1 non-teaching staff, that has not been made. In the interregnum period, what will be the consequence?
Whoever is
They will not conduct the election and
no, I am not saying
that.
I am not saying, but the election has to be conducted in a manner known to law, and has to be moreover conducted from amongst whole-time teachers and not from contractual teachers.
That is separate aspect.
Yes.
That is separate aspect,
Yes.
that the election has not been conducted in proper manner. That does not tantamount to the fact that it authorizes the body having 5 members without the non-teaching and teaching staff being elected to act. Does the act say so? That if you have
there
a
is
quorum
no
where there is no election of a
with
non-teaching or teaching staff,
greatest of respect to your lordship, what is provided
that has to be read.
And what is not provided, by necessary implication, it has to be excluded. Again I say, what is, there is a legal maxim to it. Your lordship knows, I just can't recollect, but the maxim which, in English, terminology, it says, what is provided has to be clearly adhered to, and what is not provided is deemed to be necessarily excluded by necessary implication. Please bear with us. The governing body of the college, apart from anything else, it has certain functions. In this act itself, it says that the powers and functions of the governing body shall be as such as may be provided in the statutes of the affiliating university. Section 5, subsection 5. And please see the statute, page 90, statute 97. Please see statute 97. These are the functions, and these functions are to be performed by the governing body in terms of section 5, subsection 5. And the moment, the appointment of the administrator is cancelled, by dint of page 32, whoever is appointed, had it been the position that only one person has been nominated to control the entire governing body, then an issue could have been raised, in my most respectful submission, because that person is not, does not have the necessary quorum. Quorum has also got to be read in. So the state government, in its prudence, chose to appoint at one go 3 persons, and the Higher Education Council 1 person, making it 4. The principal being the 5th person, would have been 5. And then, with the university's nominee today disclosed, it becomes 7. So if 7 members are there, the rest will pour in. And rest will pour in, in the process, prescribed. Not, unilaterally by the dint of a unilateral decision. Please, again, fall back to statute 93. Statute 93. Don't need to. Now, please see, please see statute 93 once again. 93C.
See, yes. 4 members.
Here, the role of the principal was there. In a meeting to be convened by the principal. 93C. Now, please compare it with section 5, subsection 3. Who are to be there? 3 whole-time teachers, including librarians, to be elected from amongst them. It does not say that the principal will convene a meeting to elect. Principal will issue the notice. Principal without taking any, and here again, the conduct. Please see after. Please see page 44 of the first writ petition. He does not say for a moment that the president of the governing body is not there. What does she say? At the outset, I would like to acknowledge your deep awareness towards education at large. Page 44. By which I am grateful to be moved. And then she draws the president's attention to certain statutory provisions. Then she refers to page 45. She falls back to statute of the Calcutta University. These provisions, by dint of section 21 of the present act, have been obliterated. They cannot be employed here. Her case is that the governing body, according to her, was not, that is a subject matter of debate. Now she, therefore, says that please do not hold the meeting. The meeting is held with quorum and a show cause is issued. She comes to your lordship's court, tries to persuade for whatever reasons, the matter is now before my lord. During the interregnum, we have decided to place her under suspension because of various other reasons, apart from the reasons disclosed in the show cause. We have decided to place her under suspension. She has thrown a challenge to the suspension. Today, factually, in the second writ petition, your lordship will be astounded to see, these are her pleadings. She questions to the extent, I will most respectfully first submission to your lordship is, though I am not appearing for appearing for please see the pleading in paragraph 38. সেটা আমি জানি কিছুক্ষণ তো চলবে ডেফিনেটলি কিছুক্ষণ চলবে as the said respondents, please see, this is the level that a person can stoop down to. As the respondents 9 to 10, along with Mrs. Ghatani, the alleged vice principal, pausing here, the vice principal has been appointed by the state government, and there is no embargo to appoint a vice principal of the college. And Mrs. in her Mr. Hobe, Mrs. Montudas, if get hold of the college finance, they will mutilate the entire funds, taking shield of respondent number 8 as their habitual unscrupulous persons. Can a person questioning a particular charge sheet, questioning a particular suspension or a show cause, go to this level of hurling allegations against each other, frivolous allegations at that? What is the basis? And these paragraphs have been affirmed as submission. Then I put this question to myself, why have these paragraphs been incorporated in the writ petition? Just to prejudice the court? What is the evidence in support that these persons are unscrupulous? Appearing for some of the respondents, appear at least for 9 to 11.
Yes.
This is not the way allegations are made. I could have understood the issue is show cause by an authority without jurisdiction. I have tried to, my lord, persuade your lordship to hold that the governing body in its present form, and unlike statute 93(2), it did not contemplate a situation like 93(2). Section 5 is extremely clear, and section 5 meetings are to be held. 1/3 constitutes quorum. With that 1/3, my lord, decisions have been arrived at. She might not be happy with the decisions. She might be displeased with the decisions. But the decisions stare at her face. She has to respond to the call of the governing body. She has to respond to the show cause. Since she chose not to respond, her personal animosity towards a set of teachers. Today, I am at the outset, someone wanted to intervene in the proceedings on behalf of Montu Das, and kindly looks into the nature of allegations leveled against them. I put this question to myself, in a challenge thrown to a show cause or a suspension at the instance of so-called alleged governing body, purported governing body, whether these allegations can be roped in. Kindly looks to her averments. I am not representing, but at least I am representing 9 to 11 in the second writ petition. If this sort of an allegation is made, that is enough for 9 to 11 to have an animosity towards her. Her responsibility as the principal was to create an atmosphere where the college can function smoothly, where the college can function. And please see, after this, I did not invite your lordship's kind attention to this document. Please take the trouble to straightway, come to page 66.
Can we continue tomorrow, Mr. Bhattacharya?
Well, can it be day after tomorrow?
No, it's very difficult. Lose thread to complete it.
Not
Please
I
complete.
continue the matter because Mr. Dottu was having some problem. Yes, tomorrow.
So everybody,
Be there tomorrow.
I will be there, probably, justice. Yes.
Which time?
হ্যাঁ? 3:30 ডেকে দিলে হবে। ফার্স্ট হাফে সকালে
With us? But 2 o'clock? Oh, 2 o'clock. No, Justice Strategy has fixed a matter. I'm sorry. Okay, may it be day after tomorrow, 2 o'clock. So what is the problem, sir?
The problem, we are suffering like anything. Of course.
Because I also asked Mr. Dottu will be filing an affidavit in opposition.
So will I. I will also be filing an affidavit.
Will be requiring a copy, my lord, because there are certain allegations which have been leveled against me.
That direction will be given after he finishes.
In the meantime, if a copy is served upon me today, my lord, so that I can go through the.
ও তো party নয়।
No,
He's not a party.
He has appearing on behalf of.
The allegations have been made against his client. Who are you appearing for?
I'm appearing for Montu Das and.
But you to add him as a party, give him a copy so that he can also make it.
Unless he adds me as a. He has to add me as a.
I'm granting
I'm
you
really
the
add
to add him as a party.
Not
He
if
is
I
appearing.
suppose if I lawsuits direct me to add. But if I do not add him, he's nothing to. He doesn't have any audience.
Then he has to withdraw the allegations contained in the writ petition.
কি allegation করেছিল?
Each and every paragraph contains,
It is
allegations to the extent of portraying them to be criminals.
Yes,
He
and
has
there is a
indicated paragraph 38 has it. I don't know.
paragraph 21 to 28, and my lord, there is a mention.
Paragraph
of
20
another
জানছো কি করে
litigation.
তুমি then?
But I was just going through this
Just
from a
going
learned
through.
friend.
No, সে তো বলেইছে at the outset ই বলেছে।
Add him a party. In which one? Which writ petition?
Second one.
Second one.
Okay. But Mr. Subir Chandal, learned senior advocate, who concludes his argument. The Kishore Dottu, learned advocate general, also concludes his argument. Argument is placed on behalf of respondent number 7 to 10 in first item, 1 5 something. 3. Okay. 11 to 10 and 8 to 11 in the other writ petition by Mr. Vishnu Bhattacharya.
Bhattacharya na Bhattacharya? Bhattacharya.
Due to paucity of time, the hearing could not be concluded. Is this matter tomorrow? কালকে কিছু motions নিয়ে 2:30 থেকে করে দাও 2:30 tomorrow
Yes,
2:30
I'll try to.
don't try once you have started you can
বলেই ফেলেছি
30
Mr. He is going to detain me in courtroom number 7. He is my other side I have to tell courtroom number 7 that courtroom number 42 has fixed the matter.
2:30 he will conclude in that court by 2:30. Liberty is granted to the petitioner in WPA number, which is the other number is 2094022025 to implead Mr. Montu Das
Mr. Montu Das and Mr. Konok Kumar Jana.
and Mr. Konok Kumar Jana as the necessary party. Petitioner, learned advocate for the petitioner, is directed to hand over a copy of, what is your name?
Sumitabo Chakraborty.
Mr. Sumitabo Chakraborty, learned advocate appearing for Montu Das, Mr. Montu Das and which Jana? What Jana?
Let Konok Kumar Jana.
Konok Kumar Jana. Okay. This matter tomorrow. Hey, বইটা কার আছে? Mr. Sannal, this is your book?
Yes.
Please bring it tomorrow.
Okay.
এর সাথে রাখো তো।
এটা আপনার এটা হ্যাঁ আমরা দিচ্ছি এটা জেরক্স করে দিচ্ছি এটা জেরক্স করে
আমরা এটা নেব মোশন নেব তো
হ্যাঁ কিন্তু একটাই
দাদা করে দুটো কি যাদের অ্যাড হবে
এটা স্যার
Item number 182.
Well, this is my application, my lord, for intervening, addition of party as a respondent.
Yes.
The writ petitioner, you have to be here. But affidavits are complete.
But only thing, my lord, in this writ petition, what I am challenging, now, my lord, I have a sanction building plan. While I was making the ground floor is a very old, more than my lord, 25 years. My predecessor, my father has a sanction building plan. Now thereafter, I applied for the further sanction building plan that has been granted. I started the construction work. At that juncture,
Report.
at this juncture, the Panchayat authority issued a stop work notice. My client challenging that stop work notice came up before your lordship's court. Now, my lord, during pendency of the writ petition, what happened, my lord, the private respondent, my lord, who is before your lordship filed.
It was at the behest of my
May I
complaint.
just comment, my lord, একটু বলে নিই আমি। Now, what happened, my lord? Subsequently, my lord, I came to learn that, my lord, the person who applied before your lordship, my lord, for addition of party, their husband lodged a complaint before the Panchayat authority, and surprisingly, on that day when my lord complaint was lodged, on that very day, this stop work notice has been issued. No, your lordship now is taking up the Panchayat, but your lordship will find for the purpose of the inaction we are coming, we are filing writ petition. At the moment, they filed a complaint on 18th. On the very same day, this stop work has been issued. Now, my lord, this person, my lord, who applied before your lordship for addition of party, they filed a civil suit against my client before the, my lord, Barakpur court. In that court, my lord, but the allegation is that I am encroaching, I am making construction with certain prayer. Now, my lord, they obtained an ex parte order. I appeared, filed objection. Upon a contested hearing, their injunction application has been dismissed. Now, if your lordship consider their application for addition of party, they have very, my lord, I should not use this word, cleverly did not mention about the pendency of that title suit. Although one document has been annexed with the annexure, but in the body, my lordship will not find anything. Now, my lord, be that as it may, my lord, what I am praying before your lordship, subject to correction, but the Panchayat authority has issued a stop work notice. Now, my lord, what my client is apprehending, my lord, your lordship has experience, my lord, now the Panchayat is not taking steps, for that we are coming. Now, my lord, kindly direct the BDO to conclude a proceedings. My lord, if I have a sanction plan, they have nothing to say. If I am making any unauthorized construction, BDO will take steps. Now, my lord, if required, my lord, BDO will give an opportunity of hearing to them also. But kindly dispose of the petition, because for this stop work, my lord, my building materials, everything has been stacked. Now, my lord, rainy season, 50% has been damaged. Now, my lord,
The video will not do it. No?
why my client is apprehending before the Pradhan?
You cannot skip.
May I be permitted
Madam,
to place a few things, Lordship?
Madam,
Wait.
now, my lord, if your lordship see once, না জজ সাহেব যেটা বলছেন প্রধান তো অথরিটি, তার এগেনস্টে কিছু হলে তখন ভিডিও চুপ কর। This report has been, এটা আজকে দিয়েছেন? This Nirman Shah, this my lord, all these things your lordship will find surprisingly in the application for addition of party filed by my learned friend. I don't know, my lord.
My lord, these are my documents.
Now, my lord,
Therefore,
we
it is
have
part of my
we have
application.
not yet received. Now, my lord, for
I
that
have served a copy of it upon my learned friend.
for that reason, my lord, we are apprehending if your lordship,
Yes.
if your lordship instead of Pradhan, if your lordship direct the block development officer, because why we are apprehending? Kindly see only one page, my lord. But kindly see their application for addition of party. Application for addition of party when they lodge the complaint. But kindly turn to once, my lord, their complaint at page 18. না দুটো একই ডেটে আমার প্লিজ রিড পিটিশনটা দে।
If this inspection has been conducted, then what thereafter?
My inspection without serving any notice, my instruction. Therefore, if your lordship direct the authority concerned to dispose of the proceedings which they have issued, but they will inspect in my presence, my person will be there, and if ultimately they found that there is an unauthorized, the proceeding will be initiated. I kindly dispose of the petition. And one thing, my lord, why I am apprehending, my lord, before the my lord, the Pradhan, if your lordship see once, my lord, kindly see once, my lord, the application. My lord, kindly see page 11 of the writ petition. But kindly see what I am challenging. I am challenging annexure P2, page 11. And addressed to my client Dilip Rai, মহাশয়, have you got it?
Yes.
এত দ্বারা আপনাকে জানানো যায় যে আপনি সকল প্রকার নির্মাণ কার্যাদি বন্ধ রাখিয়া বাড়ির অনুমোদিত প্ল্যান ও সংশ্লিষ্ট জমির কাগজপত্রাদি সহ অত্র প্রাপ্তির সাথে সাথে নিম্ন সাক্ষাৎকারীর সাথে সাক্ষাৎ করুন। কাইন্ডলি সি দ্য ডেট 4th December 2024. Have you got it, the date?
Yes.
Now kindly see once, my lord, they are applicant for addition of party. But this CN number, your lordship will find, my lord, CN 1 of 2025.
Yes.
I will request your lordship kindly see page 17.
My lord, this is an
My lord,
admitted position.
But kindly see the date when the complaint was lodged. But 4th December complaint lodged, and my lord, on the very day, my lord, this so-called this stop work. Now, my lord, if your lordship thinks, my lord, my client's apprehension, the my lord, Pradhan, my lord, if your lordship instead of Pradhan, my lord, or if your lordship direct the Pradhan also, let an inspection be done in presence of us, and an opportunity of hearing be given to all the and pass necessary orders, my lord.
My lord,
Yes.
my lord, I have one submission, my lord. Just 2 minutes. I was not given an opportunity. This is my application.
In this application, I have two
Allow
submissions.
your application.
Very
But
good.
if that
is
be
allowed, my lord, if a direction is passed for conducting an inspection, my lord, I should also be informed, and I would like to be there present when the inspection is being carried out.
But
my lord.
only one.
Because admittedly, my lord, they have continued illegal construction even after the issuance of the stop work notice. I have annexed that document in my application.
Only one
to
submission.
which he has not given a
I am
reply.
regarding his addition, her addition of party. I have not said anything. Only one thing. But kindly see once, my lord. But they have who has lodged the complaint, my lord. Kindly see once. Complaint has been lodged by at page 17. Your
Yes.
lordship will find the husbands.
And the property is in my
Let
name.
me. Both party
No,
can't
you have
argue.
not, well, I have not been given any opportunity to place my application. My learned friend has been submitting on my behalf.
But kindly see the name of the applicants, my lord. Kindly see once. The name of the applicants are
The husbands of the owners of the property.
Alpona Noshkar, Baby Shorkar. And who has lodged the complaint, my lord? Kindly see. Sachin Kumar Noskar, Pranab Sarkar, Sumon Basu.
Who are the
Now, surprisingly, kindly see, which has not been annexed, kindly see my reply against my opposition against their application for addition of party, but kindly see the plaint, my lord. But I say, if the complaint has been lodged by a person, he ought to have filed this application because others don't have right. This person, let me complete. But what happened, my lord?
to place my application?
Let me complete, then you will place. Now, my lord, kindly see the plaint, my lord, once. But kindly
Yes,
turn
kindly takes up the plaint.
page
The
9.
plaint has nothing to do with this matter.
Kindly see the page 9 of my opposition. The plaint.
My lord, the plaint is not even regarding any sanction deviation from any sanction plan.
I will show.
What is your opposition?
My opposition has been filed before a lordship's court, my lord.
Completely different cause of action.
Dilip Kumar Rai, my lord.
Yes.
But kindly turn to page 9. Who has filed a suit? This Alpona Noskar, Baby Sorga. Who is the present applicant before your lordship? Now against whom? Dilip Rai. What is the suit for? Declaration and permanent injunction. Now, my lord, kindly straightway come to, kindly see page 12, paragraph 11. The defendant has no right, title, interest in to construct any construction without leaving any space over the common passage. This is one. Second, the plaintiff has every easementary right to the present descheduled property, but due to illegal construction of the defendant, the easementary right of your plaintiff are infringed, and your plaintiff are failing enjoying natural light and air. But this is, may I just complete, please? But kindly, in that score, kindly see the prayer in the suit, page 13. A decree of declaration that your plaintiff has every easementary right over the descheduled property. Decree for declaring construction over C-scheduled property as illegal. Decree of permanent injunction by restraining the defendant to construct any construction over C-scheduled property. Now, my lord, causing for a moment, my lord, if kindly turn to the next page, they have obtained an ad interim order of injunction. Subsequently, if your lordship see,
that
page 70.
order is not there, lordship, and this is not relevant for the purpose of this application.
And if I be permitted to complete my sentence, my lord, why I am showing before your lordship? Because, my lord, in parallel proceedings, they can't do.
This is not a parallel proceeding, my lord. That is my submission, which I am not being allowed to make by my learned friend.
But if your lordship dispose of the writ petition by directing the Pradhan, and when your lordship is disposing, no question subject to correction, no question allowing their application for addition. And if your lordship direct them, they may give an opportunity of hearing, they may participate. But once your lordship will allow, that your lordship has to decide, because one person is making the complaint, other person is filing the application for addition of party. Therefore, they have to choose who will participate. Because, my lord, one person, my lord, the husbands are making complaint against me on the basis of the same stop work notice has been issued. Now, this addition of party has been filed by the husband, the wives. They have to choose who will represent before the Pradhan.
May I say something, my lord? My lord, this writ petition cannot be disposed of, my lord. Because, my lord, the reason why it cannot be disposed of, my lord, because there have been several complaints made against these people. My lord, it so happens that we have also made a complaint, and, my lord, the Pradhan has issued
stop work notice which has been issued.
Yes, my lord.
Taken to the logical conclusion.
Yes, but it has to be taken in logical conclusion. But, my lord, this submission that I should not be made a party or my husband has made a suit is absolutely irrelevant.
If they are the owners of the party and implead them, why the complainant?
I beg your pardon.
Why the complainant will be impleaded?
But it is at my behest that the stop work notice has been issued.
My means, please specify.
It is my husband. They are the husbands of the petitioners over here, my lord. But for this ease of filing, my lord, this has been done. The husbands of the petitioners. But kindly see.
Party and you cannot file a complaint.
My lord, kindly sees their names are also there, my lord. It is not. It is a technical difficulty.
Court swearing affidavits and filing applications for your impleadment.
Yes.
But you cannot file a complaint before the Pradhan.
My lord, for whatever reasons we have filed the suit, we have come and filed the application. It is the same party. We are not strangers to the dispute. That is the difficulty. But, my lord, if an inspection is already has been carried out, as per the inspection report, there has been deviation. Let me be a part of the proceedings when this inspection is carried out.
Since there is a stop work notice, he will conduct an inquiry.
Yes, my lord, let it
for
be.
both the parties.
Yes, my lord.
If there is a deviation, then
We will
have to suffer. If there is no deviation as per sanction plan, if he has
my lord, there is already a deviation which is a part of the inspection report that has been given.
That is expertise, my lord.
Well, where is
One
the
of
question of it being
2025
ex parte? It was not held in my presence
and
as
one of
well.
2025
Yes,
is
my
an
lord.
application for addition of party. The petitioner contains that a complaint was lodged by the husband of the petitioners,
Yes, my lord.
respective husbands of the petitioner on 4th December 2024 and with the contention of unauthorized construction. In relation to such complaint, stop work notice has been issued by the which Gram Panchayat, local Gram Panchayat, Rajarar Vishnupur 2 number Gram Panchayat on which date? Madam?
My lord, 4th
December.
December 2024.
4th December 2024. The petitioners are the where have you stated that you are the owners of that? What is your relation to the subject land?
My lord, at paragraph 3, I have stated the applicants are neighbors of the writ petitioner and
They
are
are the
necessary
owners, not
parties.
friended. The lord, she will not find that. They are the neighbor.
We are the neighbors, my lord. We have surrounded the
Applicants are the
surrounding
neighbors
residents.
of the respondents. Seeks for addition of party. Mr. ওনার নামটা দেবেন না উপরেও দিয়ে দেবেন Mr. Solanid advocate for that. Mr. Devjit Mukherjee learned advocate appearing for. On the contrary, Mr. Devjit Mukherjee learned advocate appearing for the opposite party submits that
My writ petitioner.
opposite party writ petitioner submits that the applicants are not the complainant before the Pradhan Rajarhat Vishnupur 2 number Gram Panchayat. The complaint has been lodged by some other person. Further, he also indicates that these applicants filed a suit before the civil judge
The civil judge,
Learned
Junior
first
Division,
civil-
First Court, Barashat.
Junior.
Judge, Junior Division First Court Maharashtra, being title suit number 1455 of 2024, where you have contested that is
Yes, my lord. Kindly see page 17, 2nd May 2025. Injunction has been dismissed on my.
wherein the application for temporary injunction has been dismissed by the learned civil judge. So, however, be that as it may, it seems that the matter be relegated to the Pradhan for causing inquiry of the issues raised in the writ petition. In view of the submissions, let the names of the applicants be added as a party respondent numbers. They will be as respondent numbers.
My lord,
6
6
and
and 7.
respectively. The leave is granted to the petition.
And condition.
Get liberty to impede such and such. If you do that, leave is granted to
Yes, yes, he will.
dispose of. এবার WP এর heading করে দিন। By the present writ petition, the petitioner seeks for withdrawal of the stop work notice dated 4th December 2024. The petitioner contends that the work of construction has been undertaken on the basis of a sanctioned building plan of the concerned local Gram Panchayat. This has been issued by whom? Local
Issued-
Gram Panchayat?
I'm sorry, that has been annexed in my opposition, my lord.
Yes, yes. Gram Panchayat. However, without any basis, such stop work notice has been issued. challenging such action of the Pradhan of Vishnupur Rajarat is দেখে নেবেন একটু 2 number Gram Panchayat. The petition, the writ petition has been prepared by the petitioner. The report filed by the state is taken on record. Learned advocate for the petitioner submits that on the date of complaint, the stop work notice has been issued without causing any inquiry or giving any opportunity to the petitioner for of hearing.
But another thing, I don't know what is the complaint. Just now I received the complaint from the no complaint was officially served to me. Only the stop work.
No copy of the complaint has been served upon the writ petition. On the contrary, the learned advocate appearing for the added respond number 6 and 7 submit that there has been deviation. There has been illegal unauthorized construction undertaken by the private response by the writ petition.
My lord, the inspection report is at page 23.
And that is ex parte.
Which is depicted in the inspection report. The advocate for the state submit that matter be relegated to the Pradhan of the local Gram Panchayat to cause necessary inquiry and inspection and act in accordance with law. Upon considering submissions advanced on behalf of the petitioner as well as on a complaint lodged by
Complaint is at page 70.
Sachin Kumar Noskar, Pranav Sarkar, Sumon Bose. Stop work on 4th December 2024, a stop work notice has been issued by the local. The inspection report is annexed to the report of the state, which shows certain deviations. Be that as it may, the inspection report does not record that it has been made in presence of after notifying the petitioner. Be that as it may, consider submissions advanced on behalf of the respective parties. The Pradhan is directed, Pradhan of such and such, respond number directed to cause inquiry. Must we cause inquiry? Presence of both the parties upon notice. Thereafter, give an opportunity of hearing to both the parties. Parties are at liberty to produce all relevant documents at the time of hearing. If the material suggests that there is certain deviations, he will take it to the logical conclusion. As per section 23 of the West Bengal Panchayat.
Grateful.
This should be completed within a period of 3 months from date of communication of the sort.
Grateful.
And only thing, encroachment and other, at sometimes your worship knows that is the subject matter in the civil suit. Whether the Pradhan, while exercising that power, or whether that can be
The Pradhan such exercise such power with regard to
unauthorized.
As to whether there is unauthorized construction or deviation from the sanctioned channel.
Grateful, extremely grateful.
Item number 183. Should I appear on this?
Madam, for the petition.
I should file a report, my lord. I have a report. It's not been happened. If your lordship so pleases, I can have come back to your lordship, my lord.
Tomorrow,
Day after to, excepting 11th. Excepting 11th.
Open.
9. Accepting 11.
Lordship.
Then tomorrow,
Lord, it has to be affirmed, my lord. It has to be affirmed.
next week, the return.
Next week.
On the prayer of learned advocate, Mr. Shantanu Kumar Mitra, learned senior advocate.
No, let it be, my lord, let it be the order of the court, my lord. Let it be the order of the court. I have, my lord, report without.
Learned advocate, Mr. Shantanu Kumar Mitra, learned senior government advocate, appearing for the state seeks extension of time to furnish report in the form of affidavit
Lordship, my lord.
in terms of order dated 13th August 2024. Let such a report in the form of affidavit be filed by
Lordship.
Monday. Is this matter 16th?
Lordship.
Exceptions you will be filing exceptions by 15th.
Lord, instead of 16th, can it be on 17th?
17th, then not this side of the vacation. Because
17th,
by
17th.
15th, then they will take 2 days to file exception. Then on 17th, this will appear.
Lord, 17th.
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 Man,
15th, you file your
I would
by
file.
15th, you file. Give
Yes.
a copy. So
Yes.
that we
Malat,
can file.
instead of 15th, Malat, kindly direct to file it on by 12th, Malat, because
12th.
if it is on
12th,
15th, Malat, he has to
Next
come.
week, my lord, I would affirm it. My lord, in course of this week, I would affirm it and I will serve an advance
With an
copy to
advance
her.
copy.
I would serve an advance
17th, Malat,
to her.
there's a Vishwakarma Puja on 17th of September. There may be some
18th,
difficulty, Malat.
18th.
18th.
Malat, the matter may retain in its position.
On 18th, this will appear.
Yes, yes, yes.
In its position, Malat.
Returnable.
As returnable motion, Malat.
Yes, returnable motion.
18th original. 19th of a hearing. Where is Mr. Mitra?
Lordship, my lord.
Make it by 12th
Lordship.
so that the matter can be heard. What is the matter?
No, this is a matter
Compassionate
relating to
appointment.
compassionate
Therefore,
appointment.
compassionate.
The
12th, by
second
12th,
count
you
of
file.
11th or 15th, but I have some difficulties.
12th you file.
Yes.
15th she will file her exception if any.
Yes.
On 16th this will appear.
Yes, yes.
Mileage.
16 তারিখে দিয়ে দিন।
Yes, yes, yes.
ঠিক আছে চেঞ্জ করে দিন 12 15 16th এটা appear
18th to Lordship.
18th, 17th to Vishwakarma.
next
Good morning. I'm for the petitioner. My lord, in this matter, my lord had been
To appear for the state.
My lord, in this
So-
matter, the state was supposed to submit a report. On the last date, the report had finally been filed and I had been given a direction to file an exception. So, my lord, I have prepared the exception already.
Very
It
well.
has been affirmed.
Prior to my learned friend gives us exception to the
My lord,
report,
I am giving a copy now.
there had been 2 typographical errors in page 3 of the report in form of an affidavit, your lordship. If that may be taken into consideration, otherwise that would
paragraph
paragraph B, first, second, third, fourth, fifth line, that the meeting for removal, your lordship finds in the 5th line. It
it
will
is
be,
clearly stated that
Page
the
3.
meeting for removal of the Pradhan. This one.
it is clearly stated that
Hmm.
the meeting for,
Huh.
it will be no meeting for. And in paragraph D, in the 4th line, your lordship, in violation of section 12, subsection, it has become 1, it will be 12.
No, that can be, but this no means there is a change of circumstance.
No, your lordship, that is the quotation of statute. I have,
Now in B, if it is no, then the meaning changes.
your lordship, that is the statutory provision. The no has become somehow the
Oh, it is clearly says that no means.
but that I'll be able to establish from section 12 itself.
Okay.
only. Now, I may not be required to go through the exception. If your lordship insists me, I can come back. But the legal position is that after 2014 second amendment, no meeting for no confidence motion can be raised within a period of 2.5 years. In this case, the date of election was 11th August 23, as admitted by the petitioner through their certificate of election. And the first notice of motion was 14th August 24, within a period of after expiry of 1 year, 3 days. So in my humble understanding, the previous position was that no meeting could have been called within the expiry of 1 year, which has been done to 2.5 years after the 2014 second amendment. That is available in the recent book your lordship has. And in this aspect, your lordship, if I may refer,
My lord, if I may kindly be permitted to make my submissions, given the fact it is my writ petition. My lord. My lord, the petitioners are agree.
Section 12.
section 12.
Section 12. Subsection.
Subsection 12.
My lord, so for this case is concerned, this section 12 subsection 1 will be the operating section, given the fact that in the 2014 amendment, the second amendment, it specifically dealt with Pradhan and Upapradhan in section 12 subsection 1. So my lord, going by the statute, I'll have to admit that my learned friend has made a valid point in this. I'll not go into that, my lord. But besides section 12, my lord, kindly see section 16 for once. My lord, it is already a trite law, given that coordinate bench of this honorable court has already given a judgment to this effect, that no notice of motion can be conveyed or can be made calling for moving a no confidence motion stating anything that is in any way detrimental to the political career of the concerned person. That is a legal position. So for my client's representations or notice of motions are concerned,
stigmatic in nature. On the last,
my lord, I do agree with that. I do agree with that. Those have stigmatic contents, given the fact it says আমরা সুলতানপুর পঞ্চায়েতের সদস্যগণ বর্তমানে পঞ্চায়েত প্রধানের বিরুদ্ধে অনাস্থা জ্ঞাপন করছি, কারণ কোনো সরকারি পরিকল্পনাকে বাস্তবে রূপায়ণ করার মানসিকতা ওনার নেই এবং বারবার ওনার সহযোগিতা নিয়ে এটসেট্রা এটসেট্রা. So I'll not say that it is not stigmatic, but in any way, when the works of the panchayats are concerned, section 16 gives a very clear way out. My lord, kindly take section 15 to 16 for once. My lord, section 16 clearly says.
What do you want in the writ petition?
My lord, the fact is that 2.5 years the threshold is not yet passed. So in this position, we are not in a position definitely to go for a no confidence motion. But in any way, the panchayats meetings should be called. Whatsoever the discontents are of the locals shall be in any way communicated to the members, and the works needs to be done.
Your lordship, this is becoming a public interest litigation. The prayers are not such. The prayer is a simpliciter seeking prayer for removal or attending the prayer of no confidence motion, which was prematured, and it has already become infructuous after a period, because under section 12, once the representation is being made, no confidence motion is being made, within a period of 5 days notice are to be given, within a period of 15 days everything has to be done. They have come up after 1 year. So the notice itself is infructuous. Now all these prayers that the Pradhan should call up a meeting, that should be dealt in a different writ petition or in a public interest litigation, your lordship. This writ petition is seeking for enacting on the no confidence motion notice.
My lord, a meeting can be called by only 3 members. Only 3 members will suffice to call for a meeting.
The purpose of this writ petition is not such, your lordship. This is for removal of the Pradhan.
The necessary quorum is 3 members, my lord. Here, 15 out of 22 members have participated. They have raised their voice.
I ask my
prayer in B.
lordship. Lordship, a writ in the nature of mandamus be issued by directing the respondent number 2 herein its main agent assigns to forthwith take steps in terms of section 12 of West Bengal. Section 12 deals with motion. Section 12(1), they are giving a notice of motion. They have asked the authority, they have prayed from this court to pass a direction upon the authority to act in terms with section 12. How can it be done when it is hit by section 12, subsection 12, Your Lordship? Because within 2.5 years, this notice of no confidence motion is not maintainable.
This is removal of Pradhan.
Lordship, removal of Pradhan. Their prayer is throughout. Lordship. Your Lordship, if I may cite one division bench judgment in this regard.
Exception to the report of the state respondent number 2, comma,
Judgment
filed by the
reference.
petitioner is taken on record, copy served. By the present writ petition, the petitioners seek direction upon respondent number 2, Block Development Officer, Kalna 1, Development Block. Which paragraph?
Which paragraph, Tanvi?
Your Lordship, there is no paragraph number, Your Lordship. I have marked the starting position. We have given our anxious consideration. It is in the 5th page, Your Lordship.
Hmm. 2019.
I believe this judgment would help my learned friend as well.
Yes.
Uh,
Where is the other copy of
Number 2, Block Development Officer. Forthwith takes steps in terms of section 12 of the West Bengal Panchayat Act 1973, herein after as
My lord, I am relying on one judgment, a very 2 pages judgment of this honorable court. Let my lord, similar observation be made of the ratio set in be upheld in this lordship's order as well as in the last paragraph, not numbered. Starting with in such circumstances. 2015 SCC online Cal 43. So for this judgment is concerned, my lord, we are similarly circumstanced.
But this goes against you.
My lord,
liberty was not granted.
My lord, liberty was not granted. But herein, my lord, Justice Bose had been pleased to observe that liberty is prayed for to issue fresh requisition. I do not think any specific leave or liberty from the court is necessary to initiate any action. Similar observation may kindly be.
That is always there, Your Lordship. I have also brought a similar judgment which I have placed before the court, but it is not required. After 2.5 years, everybody is at liberty.
Executive
The petitioner contained that there has been inaction on the part of contained that petitioners are the elected members.
Are all elected members.
Petitioners are the elected members of Sultanpur Gram Panchayat.
Petitioners before your lordship are 15 in number from among 22 members in total.
The petitioners made representation to respond number 2 to court, herein inter alia expressing their lack of confidence on respond number 5, who is the Pradhan of Sultanpur Gram Panchayat, on account of non-cooperation by the said respondent in implementation of government project allotted to the state Gram Panchayat. However, no steps have been taken by respond number 2, Block Development Officer, Sultanpur Development Block, under section 12 of the Act of 1973. So and so, learned advocate for the petitioner, hence this writ petition over there. Petitioner submits that the respondent number 2 ought to have taken steps for removal of the Pradhan who is not acting for implementation of the government projects and taken steps in accordance with the no confidence motion submitted by the petitioners in terms of section 12 of the Act. On the contrary, Mr. Tanvir J. Mondol, learned advocate for the state, submits that the election has been held on which they have been elected on which date?
11/8/2023, Your Lordship.
The election
11/7/2023.
11/7/2023. Election of the Pradhan.
No, that was the date of the election. The election of the Pradhan was
After that.
after that.
That was the more shortened.
Malad.
Held after July 2023. As per section 12, subsection 12.
Malad, the applicable section would be subsection 1.
Subsection 12 of the Act of 1973. It precludes the majority members from bringing a no confidence motion against an elected Pradhan unless a period of 2.5 years expires from the date of his election. In order to appreciate the aforesaid issue, he relies on the decision of the Honorable Division Bench, Mat 1898 of 2020. 1898 of 2020. Pradhan, फिर देखें मोहित बातन ग्राम पंचायत बातन मंटू सरकार. In order to appreciate the aforesaid issue, it would be profitable to reproduce section 12 subsection 12 of the Act of 1973 as hereunder. এটাকে put করবেন. Upon bare reading of the aforesaid provision, it manifests that no meeting for removal of Pradhan or Upo-Pradhan under this section shall be convened within a period of 2.5 years from the date of election of the Pradhan or Upo-Pradhan. The application of the petitioner for removal of the Pradhan has been made within a period of 2.5 years. Such being the position, the petition falls short of merit, accordingly dismissed. All connected evidence. Right. তো বই আছে next.
Number 185.
My lord, I am for the petitioner led by Mr. Shamim Ahmed. He has been retired from the brief, your lordship. He has been retired from this brief, your lordship.
For the petitioner?
Yes. It is the petition where the due to technical glitches, her salary account has not been updated. And due to non-payment of salary, she cannot join to her new office, your lordship. She is the only breadwinner for her family. That matter.
In Who is for the state?
Mr. Joyanto Sen is appearing for the state.
Joyanto Samanto.
Joyanto Samanto, yes.
What is your name?
Saloni Bhattacharya.
Ms. Saloni Bhattacharya, learned advocate for the petitioner, submits that Mr. Samim Ahmed has retired from the present writ petition. None appears on behalf of the state. Is this matter covered now? 1 week after the incident of the
Oblige your lordship.
Item 186.
The Lordship, I appear on behalf of the state respondent. There was the direction to submit the report in the form of the affidavit. I kindly submit that.
Where is the petitioner? None appears on behalf of the petitioner. State submits report in the form of affidavit in terms of order dated 11th August 2025. You have given a copy? Copy has been served?
Yes, yes, Your Lordship.
It is taken on record. Have they given you copy of the exception, if any?
Yes.
Exception copy has been given to you.
Exception copy.
Or else suggesting the matter is adjourned, is this matter? For eviction. 1 week after.
No, no, no. No,
No.
there is no exception.
Acts of the body. Is there any- under the same heading? Hey, under the same heading. 1 week after the vacation.
Item 187.
May it please, Your Lordship, Lord. I am for the petitioner. Lord, the report was filed by the state and thereafter an exception has been taken to that effect. Now, my Lord, this petitioner, my Lord, responded to an advertisement which was published by the respondent number 2 by an dated 6 January 2021, so far as, my Lord, recruitment of women as Asha worker. Now, my Lord, she has participated in that. Now, my Lord, accordingly, my Lord, she was called for the oral examination, from where, my Lord, it reveals, Your Lordship will find, my Lord, that on 5th of April 2022, my Lord, I was standing as second, first and second. Now, my Lord, the most important part which I would like to draw Your Lordship's attention at page 17 and 22, my Lord, Your Lordship sees, my Lord, what has happened. My Lord, the age criteria, my Lord, was specifically mentioned to be, my Lord, takes the page 17, Your Lordship sees, my Lord, column 11, which is written in Bengali. আবেদনপত্র জমা দেওয়ার তারিখ 8/1/2022, 17/1/2022 বিকেল 5টা, and there was specifically, my Lord, at that relevant point of time, the age criteria that she has to be 40, within 40.
So you are reading from page 17.
Yes, my Lord.
17 is annexure P2.
I'm sorry, my Lord. But this, yes, I'm sorry.
Oh,
Some
sorry,
page-
sorry, you are correct.
17.
I am wrong. I was going through the report.
Yes, my Lord. Anyway, my Lord, that if Your Lordship takes the report, what has been relied by my friend, they have relied upon.
Page 17, you are reading it. Annexure P1.
Yes. Now, my Lord, if Your Lordship kindly takes the report once, that is 6th of January 2021, my Lord, they have not paginated, but my Lord, immediately the page which has been affirmed as an affidavit, my Lord, Your Lordship will find the page of Biggupti. I straight away draw Your Lordship's attention at paragraph 3, my Lord. সাধারণ প্রার্থীর বয়স 1/1/2000 তারিখ 21 তারিখ 30 থেকে 40 বছর মধ্যে হতে হবে। So this was the criteria. Now, my lord, while applying, I was within this. Now, what has happened now, my lord? Once the oral examination result was declared, thereafter, my lord, the procedure was that I have to face the interview. Now, that interview, my lord, with deepest respect, my lord, I was not given the opportunity of participating. I was not allowed.
Why?
That, my lord, your lordship, they have annexed a document showing my attendance. My lord, I take your lordship, my lord, saying kindly comes to, my lord, one of the documents.
What is your name?
My name is my lord Shahnara Begum. I stood second. That my learned friend is not denying also in the report.
Okay.
So, my lord, so far as the person who is the private respondent herein, my lord, the report is, my lord, she has expired, who got the job. She was standing fourth. Now, the present situation is that she is no more in this world. Unfortunately, my lord, she is no more. So, the post is lying vacant. This is one of the submissions. Now,
no, you are referring to that you attended the interview.
Your lordship has to see the date of publication was 2021. And my lord, immediately after almost 1 year, which they have admitted. So it was a call for the oral examination, 5/4/2022. So 1 year gap. So naturally, when my lord, the point which has been taken by my learned friend is that at the relevant point of time, she is rejected because of the reason that she has crossed 40. This is the short point involved. I say, my lord, when I had applied for, I was within that he is not denying. Now, so far as, my lord, in this case, your lordship will be surprised to note one more thing, my lord, that there was 2 notifications. So far as which I am relying upon 6th of January. Now, again, they, after a year, just, my lord, because, my lord, I have no problem so far as the person who stood first. She got the appointment. Now, accordingly, as per the law, the second was mine. I should have been appointed. But in this case, fourth candidate who has left this world was appointed irrationally. Now, my lord, after 1 year, when I was called for the interview, I was not even allowed on the reason when they say that you give your documents. So I had supplied my documents from where now from the Aadhaar card, they say that you have crossed your 40 years. This is what is.
Candidature was not considered. You were not allowed to appear for the interview.
They are saying that they have allowed by showing a document which they have annexed. It's a completely manufactured document, which I would like
if
to.
You have appeared in the interview, then there has to be a mark sheet.
Mark sheet.
Some marks
has to be allowed. Your lordship, I bow down to your lordship's observation. That, my lord, in the report, it doesn't appear. There has to be some marks. Without marks, it has been correctly fallen from my lord. So, my lord, the only reasoning which my learned friend, my lord, the state of West Bengal is trying to.
You lost 40 on the date of interview.
Yes.
But on the date of application, you were within that 40.
Grateful, lord.
This is your case.
This is my case.
কালকে ওপরে রেখে দেন ওইটা আছে আর এটার পর এটা নিয়ে নাও tomorrow Amit?
Yes, ma'am.
Tomorrow.
I'm so grateful. Tomorrow, my lord.
I think my matter is compulsory appropriate.
I'm going with it.
Which one item number?
189 money.
No, 188 was after the December. 188 just.
Or 188.
দেখবো So Mr. is there. Mr. Vishwabroto was there.
Yes, yes.
Tomorrow we'll see.
My lord, sorry, my lord, my learned friend who is appearing for the state was eager to record a order, but I was thinking because it is appearing tomorrow. My lord, for professional reasons, I hope, my lord. I'm so grateful, my lord. I'm deep.